866-532-9466 or 697-4297. Oh, 1200. Yeah, 243-1200. Oh, my goodness. I'm blind.
I think 243-1000 might be the comfort suites.
Well, call. Get a room with a view. 243-1200. If you want to get here on the air, as you may know, I'm live, and I'm answering your legal questions this morning. I want to start you out with a couple things. First of all, the Supreme Court of the United States is going to be hearing a case involving the Obama administration and the EPA. And it's an interesting one because back in 2007, the Supreme Court said that the EPA could regulate carbon dioxide as a pollutant and therefore go after it as a greenhouse gas, et cetera, et cetera. But in the meantime, because of the absurd result, if you actually follow the regulations, the EPA began regulating carbon dioxide and a few other greenhouse gas type ideas, but setting aside the rules as they go, saying, well, we would follow our own rules, but it would be absurd if we followed our own rules, so we're going to modify them on the fly. And that was a position that Obama took, which is, through his administration, through the EPA, that we're going to apply these rules, but we're not always going to apply these rules, and we're going to modify the rules as we go without seeking guidance from Congress or even changing the rules as they apply to everybody else to avoid, quote, absurd results. Well, the reason there's absurd results is the original Clean Air Act was not meant to regulate things like carbon dioxide, the food for plants, and the things we all breathe out. As a result, the case is a little less about whether or not carbon dioxide is a greenhouse gas and whether global warming is real or not, and more about the more pressing issue, which is can the administration, can a president of the United States constitutionally selectively enforce some laws, reinterpret other laws on the fly, and basically misuse the executive power? And I guess by my use of the word misuse, you can guess how I feel about it. 243-1200 or 866-532-9466, 697-4297, 243-1200. If you want to get in on the conversation and discuss anything you want to about the greenhouse gas, the president, legal questions. Also, the Supreme Court, and I'll touch on this in a little bit, Supreme Court of the United States is in closed-door session going to be considering 3 separate gun law cases involving the Second Amendment. And as you know, on this show, we always like to talk about gun law, Second Amendment, your rights. So if you have any gun law questions, self-defense, you want to know about anything, we'd be happy to help you and talk about it. But I'm going to talk about those 3 cases to give you a highlight of what's going on. But I wanted to talk to you about the Obama thing first. And I got Miles. Miles, you're on the air. Hey, Miles.
Mr. Rominger.
How are you?
I'm okay. Now, listen, I'm the guy who's been defrauded by my business partner of 25 years. Now, I was in the Cumberland County Court, and they wouldn't allow my business evaluation to be heard. So I appealed to the Superior Court, okay? But apparently I was late. They only allow you 10 days, and I wasn't aware of that.
Well, it's not 10 days to appeal. It's 10 days to go back to the trial court on a post-trial motion.
Sir. All right. Now, sir, I'm going to apply to the Supreme Court, okay?
Okay.
I missed the timing, okay? So what are the potholes I'm going to have to worry about there? All I want to do is get my day in court and hear my business evaluation. Why do you make it so difficult?
Why do we lawyers make it so difficult? Let me answer that question. Let me make it pretty clear to you. The Supreme Court of Pennsylvania only gives you 30 days from when the Superior Court denies you. So the first pitfall is if it's been more than 30 days, you're not going to get in. Number 2, they only review errors that are clear. And because the well-settled case law says that post-trial motions have to be filed in civil cases, you're in the procedural trap. And, folks, this is just a classic example of a guy who probably had a really good case and had the ability to go forward and prove his case, but when unrepresented fell into all the procedural pit holes because we've had that caller before, and he's told us that his business evaluator's report was not admitted into court, but he didn't have the business evaluator in court. And this comes up in my office all the time because people will proudly bring me a letter that's been notarized so that their aunt, brother, sister, cousin, sworn enemy, whoever can come in and testify by letter. And it doesn't work that way because the other side can't cross-examine a letter. So while we allow hearsay statements into court sometimes, as a general rule, you should start from the proposition that you need to have the person there. So I was representing a woman the other day in a domestic relations matter. And, of course, if you have questions about any of these things, 243-1200, 866-532-9466, 697-4297. Represent this gal in court, and she has issues where there's medical issues, and we need to bring the doctor in. And in order to bring the doctor in, well, why? To put the medical records in. Why do we really need the doctor or their staff? No particular reason, except that the other side's unrepresented. They're not going to do what an attorney would do. See, if there's another attorney, I would call them up and say, do I really have to bring the doctor in? And they'd say, no, just bring the records. But when it's a pro se, he doesn't, A, understand that, and B, he's going to try to invoke the rules on me, so I need to be prepared. So if you're representing yourself, you need to understand that you're not going to get all those niceties where another attorney might simply say, we're not going to have a fight over this, because the other attorney is going to take advantage of the fact you are not represented, as I would. Scott, you're on the air.
Hey, Carl. I'm appealing a case here in York, and it's going back and forth. I have been assigned a judge. My question is, I want to go on vacation in a couple months. I want to buy my tickets now. How's that work? If they work around that?
Well, that's a good question. I once in my legal career did not go on a scheduled vacation, because as I said at the time, mentally insane judge wouldn't let me, because he decided that I had to be in his courtroom. And the ironic thing was I actually was going on the vacation with somebody else who happened to work in a courthouse of equal stature in a different county. And they even called over and tried to wiggle it and say, hey, why do you guys have to do that day? And it was a routine matter, and it was not time sensitive. It was just an egomaniac judge flexing his muscle. In reality, though, most of the time, courts are very accommodating of vacations, okay? And so if you put it on the books, the sooner you put it on the books, the better. And what I would usually do, you have a lawyer on the other side, or you just got somebody on their own on the other side?
They're on their own as far as I know.
Yeah. If there were lawyers involved, I would usually write the other lawyer and say, I just want to let you know my client has booked a vacation so should this be a court date, we're obviously going to need a continuance. And even contact court administration about that, or the proper scheduling person, who that might be.
Yeah, I would think they'd want to be reasonable. My gosh, am I supposed to sit here and not take a vacation this summer because I have no idea when it's coming up?
Are you on for a trial, or you said an appeal?
It's an appeal. This is that case where my renter left, didn't give me proper notice.
Okay. Well, in order for there to be a hearing, you've got to list it for arbitration, or or some event has to be happening that's going to cause it to be heard. So if you filed the appeal and you wrote the complaint and they wrote the answer, it'll just sit there forever until one of you press a piece to make something happen, okay?
Well, what happened was they presented it to, it starts over again, like you said. My attorney picked it apart because they wanted costs and fees for leaving, being absent from work and all this. So my attorney countered that. And then the last thing that I got was that there was a letter from the judge saying that she agreed with this and that. So they got 20 days to, represent it or correct their complaint. That's the last I heard about a week ago, 2 weeks ago, that there's 20 days for them to respond. So
right.
Then so I'm hanging here in limbo. I have no idea what.
Right, they don't have to schedule something. So if your attorney should be able to control it sufficiently to allow you to book a vacation.
Okay, I got one other thing on district magistrates.
Yeah.
This guy's caused a lot of problems because he didn't know basic laws at 30 days' notice. He's causing me money. He's causing people the judge annoying, using up time here. And is there anything that kind of complaint you can put before?
You can write the judicial board and say, hey, this guy's incompetent, because there's a duty of competence for lawyers and judges. But you could also write the president judge of that county and explain what happened. Some of the president judges are more proactive than others because they technically run the judiciary with reaching out and saying, hey, now, of course, there's how you do this stylistically, right? But saying, hey, you guys sent this case up from below, and I'm getting a lot of these, which might be true or might not be, but he's trying to maybe make the DJ feel like he's not the only one making that mistake. And here's really the rule, so everybody knows. Kind of gently remind everybody. But yeah, there's not great quality control on who becomes a magisterial district judge because it's an elected position. So that's the same reason we get bad governors. We get bad MDJs. On the other hand, fortunately, most of them are good. And I know ones that are good that are lawyers and non-lawyers. Obviously, sometimes having a lawyer in the position is helpful because they have more legal background and more willingness to look at the rules. Mm-hmm. But in my experience, a lot of the non-lawyers who take the job seriously catch up on all the procedure they need anyhow. But yeah, you get a few bad ones, and I've had it as bad as the judge has no idea what's going on, or if you had it even worse. Yeah, I agree with you. That's what the law says, but I'm not going to do it. Like, oh wow, okay, judge.
Well, a simple thing like giving proper notice. I think what happens is a lot of people just say, well, I'm going to take the easy way out and pay it because I'm not going to get involved with attorneys. And so you get attorneys involved, you're way behind on this. Yeah,
and they may not, the other problem is people may have no idea because people want to, a lot of times when people come into my office, they show me a letter from a lawyer, they say, oh, the other lawyer said this, and now I have to do that. And I'm like, Why? Well, the lawyer wrote it. And they think just because he wrote it, it must be true. Well, when the judge says it, that's even more in most people's minds, the end of the line, so to speak, even if it's not right.
Yeah.
All right, my friend.
All right, thank you.
Thank you. Yeah. I was going to go skiing, and the judge wouldn't let me go. Can you imagine that? Cancel my Killington trip. This is years ago, like a decade ago. 243-1200. 866-532-9466-697-4297. You want to get in on the action, got a legal question, whatever you want to talk about. I think we're going to take a little break here, and when we get back from the break, we'll talk a little bit more about those NRA cases. I just want to remind you to stop by Harrisburg Beer and Cigar over in Harrisburg on Union Deposit. It's over by Ashley's Furniture and across from the Outback and the, what's that other store? The Texas Roadhouse over off Union Deposit. Great humidor. They're going to be doing tomorrow afternoon a hand roll event with Jay Castellon, who's coming up from York. And if you don't know who that guy is, he actually hand rolls tobacco, cigars, but he's a Cuban. And he's off the boat. He made the float, so to speak, and got his feet on American soil. So now he's here making cigars for us, and they are really, 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 really good cigars. And when I go to York, if I'm down there for court, I will work my way over to his shop just to get a couple. They're very hard to get, very limited in the number you can get because he can only roll so many. But he's going to be at Harrisburg Beer and Cigar tomorrow, I think at noon, so you can check him out. And he'll be there for a few hours hand rolling them. Amazing event. All right, see you after break.
You thought Boost Mobile had low prices before, but now they're dropping lower than ever for anyone switching to a Boost 4G LTE device by March 31st.
Are the prices this low?
Nah, lower. $35 a month low.
How about this?
No, try $35 a month for 6 months low.
Wow, that's low.
You're right, it's low. That's how Boost Mobile does it. They go $35 a month for 6 months low, all with unlimited talk, text, and data.
Oh, baby, for only $35 a month? I'm down with that.
Available at Boost Mobile, Best Buy, and Radio Shack. Boost Mobile. Be heard.
No, like this. Boost Mobile. Be heard.
Offer available 2614 to 33114 at boostmobile.com and select retailers only. Limited to new accounts and purchase a 4G LTE device. Rates increase after introductory rate. Coverage not available everywhere. Includes 2.5 gigabytes per month for high-speed data. See boostmobile.com/35 plan or participating dealer for details.
Have you lost your free checking? Well, Members First Federal Credit Union has the free checking account that you're looking for with no minimum balance, no monthly fees, and free overdraft protection. Plus, you'll receive a monthly cashback rebate with your Members First Visa debit card. Switch your checking account to a free Members First checking account by visiting any of our conveniently located Members First branch locations in the Cumberland Valley and Capital Region today. See how easy it is to open a free checking account and debit card with Members First Federal Credit Union. Meet the friendly staff and see why our over 200,000 members are Members First members. Open a free checking account today and see how easy it is with no minimum balances, no monthly fees, and free overdraft protection. Members First Federal Credit Union. We put our members first. Visit us online and bank with us from anywhere in the world at membersfirst.org. That's members1st.org. Federally insured by NCUA. We do business in accordance with the Federal Fair Housing Law and Equal Credit Opportunity Act. Other restrictions or conditions may apply.
And now, the Trindle Chicken. He wants everyone to know the Trindle was just voted best wings in Carlisle. Mr. Chicken says if you love sports and great wings, you'll love the Trindle Inn, 1941 Trindle Road, Carlisle. Call 249-7081 for wings to go. Cold beer, sports, the best wings in Carlisle. And oh, the best burgers around, too. All at the Trindle Inn, Trindle Road and Fairfield Streets, Carlisle. And now, back to Weekend Appointment with attorney Carl Rominger live on Country Gold FM. Call Carl now with your legal questions at 243-1200, 697-4297, or toll free from anywhere in the mid-state at 1-866-532-9466.
Okay, welcome back. Carl Rominger here. As you know, 243-1200. I won't repeat all the other numbers. Get in here if you have a legal question, whatever you want to talk about, child custody, support, criminal law, your neighbor's roof, your neighbor's trees. We had a great show last week with Eric Verodi answering all the questions about trees and valuations. And in fact, that spurned a huge discussion on Facebook. Don't forget to follow us on Facebook, Rominger, the Carl Rominger Show, or Rominger Law Offices, either one, or myself, Carl with a K, Rominger. Jump in there because we have a lot of good discussions and follow-ups on these shows. And, of course, people ask me legal questions throughout the week. Wanted to tell you, though, about this going on with the Supreme Court. They're going to hear 3 gun cases. I think the most important one, and here's the essential question in the first case, is whether a nationwide class-based categorical ban on meaningful access to the quintessential means to exercise the right to keep and bear arms for self-defense can be reconciled with the Second Amendment's equal protection guarantee and this court's precedents. The second case is if the Second Amendment right to bear arms includes the right to bear arms in public, if a responsible 18 to 20-year-olds can bear arms, and if 18 to 20-year-olds can bear arms in public. One of the issues that's come up is a lot of states have said people under the age of 21 can't bear an arm. And, of course, at 18, you're supposed to be a full citizen and an adult, and I guess you can't drink, but maybe you should be allowed to carry a gun. In fact, the other issue that the NRA is really pressing in these cases is the idea, because some states have said, okay, yeah, the Supreme Court said you have a right to keep and bear arms, but only in your house. And you can't carry that gun with you anywhere else you go because we're allowed to regulate that. And that's kind of what the push is to say. And there is if you look, there is a separate right to keep and bear arms. In other words, keeping arms and bearing arms are 2 separate questions. And obviously, if you keep something, that would be at your house. Bearing it would be as you're out and about. That's kind of the argument. So, long story short, it looks like we're going to get some new precedent on the Second Amendment, and we'll see where that goes. Obviously, in the last few years, the courts have clarified that there is a Second Amendment right because that seems to be so controversial for so long. You know, you have all these other numbers, alphabet soup of rights, but nobody was sure if you had a Second Amendment right because the courts just couldn't come out and say it. Remember this. Most gun control is simply the government abrogating your Second Amendment rights. In fact, the original Second Amendment, as it was passed and understood by the people when it was created, allowed anybody to own the exact same firearms the government owned. The citizen was able to be as armed and as dangerous as the government itself. And part of the reason was our forefathers felt that standing armies and armed governments led to tyranny. And so allowing every farmer and deckhand and any other person in the economy to arm themselves equally and in parity with the government was essential to freedom. Over the years, we've lost that as we've lost a lot of other rights. I mean, Fourth Amendment's been modified down. The Second Amendment was modified down. The First Amendment's always been a little controversial because right after, if you'll remember when Madison and Jefferson were running against each other. Yes, Hamilton was never president, in case you're wondering. Somebody asked that the other day. When Madison and Jefferson were running against each other because the Anti-Sedition Act was going on, they were locking up news editors. That hasn't happened in a couple hundred years until recently when the Obama administration began beating up on these poor news reporters, which, of course, we hear very little about from the other reporters, tapping phones of reporters and doing subpoenas, grand juries, and dragging them in to find out about leaks, et cetera, et cetera. The press is probably under more oppression now than it has been in years. And, of course, it's all at the same time we're learning about the NSA and the IRS and all those other scandals. So my point being is the First Amendment was one that may have had its nadir a while ago and maybe on the way down. But the Second Amendment, the Fourth Amendment, they peaked early, and they haven't been back in full force since. But maybe the Supreme Court's in the process of digging out the Second Amendment for us. So if you have any questions on gun law, or you want to just kind of shout out about gun topics, 243-1200. If you have a legal question about divorces, child custody, anything like that, you can jump on the air with us, 697-4297 or 866-532-9466. I'm also trying to round up Mark Virginis this morning as he's our big financial guy who gives us a little advice on the show from time to time. Trying to get him on because I'd like to see what he has to say about what's been going on in the stock markets, but I haven't been able to get a return from him yet. So if you know him, hit him up for me, and we'll try to get him on here. Had a recent interesting hearing the other day. I'm in court, and we're going along, and the other side is testifying that my client. Well, the theory was that my client had stolen something, and that he was the absolute guy that did it. Now, and he identified my client to the police from a photograph. And turns out my client had been at the house a couple of times legitimately because it was one of these houses that's got people visiting it for various reasons. So he'd been there legitimately. So the theory was, well, why did he pick this guy as the guy who was there when things were stolen? Well, he must have saw him there other times and just assumed it was the same guy. So, but of course, people always think, oh, the police do this great investigation and everything's going to be nailed down. The guy must be guilty. Okay, so let me break the testimony down. So you saw my client there? Yes, I saw your client there, Mr. Ominger. Oh, okay. How far away was he when you saw him? Sounds like a movie here. Oh, about 50 yards. About 50 yards. Okay. Did you? Well, then I went over and I talked to them. Oh, you talked to them, so you were close. Well, I wasn't close to him. What do you mean we're close to him? Well, he was inside the house when I talked to the other guy, so I didn't see him up close. I only saw him from 50 yards. What was he doing when you saw him from 50 yards? Oh, he was in the truck pulling into the driveway. Oh, so the best view you got was he was in the passenger side of a truck 50 yards away. Yeah. Well, how do you know it's the same guy that comes? Because he's the same one that comes and mows the lawn all the time. Oh, he comes and mows the lawn all the time. Oh, interesting. You sure he mows the lawn? Because turns out, there's another group of guys who mow the lawn at this place. Totally different group of guys. So you're absolutely sure he's the guy that mows the lawn? Yeah, he's one of the guys that mows the lawn. I've seen him on the mower 2 or 3 times. I absolutely recognize him. Anyhow, my point on this is, even at the district judge level, the judge is like, I don't think we're going to bind this over because it doesn't seem to be we have the right person, at least without more evidence. Obviously, they have the wrong person. But what I bring this story up is to show two points. Number one is a witness, when shown a photograph by the police, is absolutely certain that's the guy they saw. But only under the careful light of cross-examination, when you start to break it down, can you understand when and where they saw the person. And and under what circumstances. So, number one, had we not done a thorough cross-examination, we wouldn't know. Number two, the certainty with which somebody can identify somebody when obviously they didn't see that person at all because all their information was wrong. I truly believe this person certainly saw somebody go into the house and may have looked from 50 yards through a truck window like the person they thought they saw previously mowing the lawn. Doesn't mean it was my guy, though, because they never mow the lawn. So the information just totally bad. But this guy takes the photograph of my client when the police show it to him and says, oh, yeah, that's the guy. The other problem is it may have been a little suggestion when the police are showing photographs and they've got a theory on what happened. Because, see, they thought, imagine this, there's a house where there's different crews coming and going on a regular basis. And they came up with a theory that one of the crews was probably one of the guys on one of the crews and his partner were probably the thieves. So once they came up with that theory and they picked the description and decided that was the guy, they picked a couple photographs to show of the employees of the one place, but not the other. And the witnesses always think, well, here's the photographs of the guys that work for the one company that we think did this. And the witness goes, oh, yeah, that looks like the guy because I've seen him here before. So my point on all this is don't just believe because somebody says they saw somebody doing something that it must be true. Eyewitness testimony is just notoriously terrible. Number two, don't believe that just because the police have hunted down somebody or looked into something that it must be true. So that would be my thoughts for you. We're going to take one more quick break here, and we'll be right back.
Hi, this is Dave Crown, the new owner of Cartridge World in Carlisle. I am excited to announce our new location at 200 South Spring Garden Street at Castles Commons across from Giant. I now have a fully stocked retail location to better serve your personal printing needs. We'll be open Monday through Saturday. We'll be able to answer any of your ink cartridge questions and save you 20 to 40% off big box retail prices. Our goal is your complete satisfaction. Come visit us at 200 South Spring Garden Street or call us at 249-8900.
IESI is your local, dependable, full-service trash hauling and recycling company, offering both home and business trash hauling and commercial roll-off services.
This is Kim Kesselring. If you need trash or recycling services anywhere in the Cumberland Valley, call me at IESI at 729-0601. That's 729-0601. We're a progressive waste solutions company.
Go to IESI.com for details on the service that fits you best. IESI, local hometown folks working for you. Call them today at 729-0601. IESI, 729-0601.
Hey, Dad, I passed my driving test.
Nice license.
Shows off the facial hair, right?
Facial hair.
Anyway, Dad, I think it's time I had my own car.
Couldn't agree more.
Really?
Let me just grab the laptop and hit up dexknows.com. Let's see here. Used cars, no credit necessary. Perfect.
Whoa, sweet ride. How did you do that?
With Dex. When you need something here and you need it now, you gotta Dex it. So, let's use Dex to find you...
Hey, I'm Mike. Nice facial hair, kid.
Who's he?
Top-rated mechanic. The way you drive, you'll need one.
Good call.
Hey, Mike, you need any help in the front office?
You need a job?
No, but my son does.
I do?
How else are you gonna pay for all of this?
Oh.
Need something local and need it now? Find it with Dex in the book at dexknows.com or on your mobile phone. You'll get the sharpest local info, reviews, and advice fast. Dex, results for the here and now.
It's another great weekend of high-speed excitement on Country Gold Radio, brought to you by these proud racing sponsors.
Osborne Renovations, specializing in quality home improvements. Call them at 701-5458 and find out how teamwork makes the dream work. By your locally owned Verizon store at 1156 Walnut Bottom Road, Carlisle. By J&A Lawn Care and Landscapes of Newville. Call Sean at 440-5682 for your full-service lawn maintenance and landscaping needs. By Members First Federal Credit Union, with a location near you throughout the Mid-State. Discover how at Members First they put their members first. By Dave's Tractor World, with locations in Gardners, Hanover, and at 1787 West Trindle Road, Carlisle, specializing in lawn and garden and small engine power equipment sales and service. By Crumbs Cafe at 101 Watt Street, Mount Holly Springs, serving wonderful breakfasts and lunches featuring delicious home-style food. And by Advantage ChemDry and Flooring of Shippensburg. Call 532-8676 for expert carpet cleaning.
You thought Boost Mobile had low prices before, but now they're dropping lower than ever for anyone switching to a Boost 4G LTE device by March 31st.
Are the prices this low?
Nah, lower. $35 a month low.
How about this?
Now, try $35 a month for 6 months low.
Wow, that's low.
You're right, it's low. That's how Boost Mobile does it. They go $35 a month for 6 months low, all with unlimited talk, text, and data.
Oh, baby, for only $35 a month? I'm down with that.
Available at Boost Mobile, Best Buy, and Radio Shack. Boost Mobile. Be heard.
No, like this. Boost Mobile. Be heard.
Offer available 2614 to 33114 at boostmobile.com and select retailers only. Limited to new accounts and purchase a 4G LTE device. Rates increase after introductory rate. Coverage not available everywhere. Includes 2.5 gigabytes per month for high-speed data. See boostmobile.com/35 plan or participating dealer for details.
At And now, back to Weekend Appointment with attorney Carl Rominger live on Country Gold FM. Call Carl now with your legal questions at 243-1200, 697-4297, or toll free from anywhere in the Mid-State at 1-866-532-9466.
Okay, we're back. Carl Rominger here, 243-1200, 866-532-9466, or 697-4297. Now, I get this question all the time about custody. Is there a bias against men in custody, and are women more likely to get custody? And I think sometimes the answer is yes, because I think some judges are biased in their decision-making process, even if it's not conscious. And, of course, sometimes there are thoughts that there are certain realities about infants and mothers that don't apply, so that a 6-month-old and a mother probably have maybe a better connection in the sense of breastfeeding or things like that. But, it got me thinking, like, well, we don't think sex is an issue in custody anymore. How about race? And, it was as late as 1984 when the Supreme Court ruled in a case called Palmore versus Sidoti that you couldn't use race as a factor in making a custody decision. So I want you to think about that, because we say segregation ended in the 50s and Jim Crow was struck down. Well, as late as 1984, our Florida courts, where that case came out of, and other states, were actually awarding and modifying custody on basis of racial factors. And in that case, a woman complained that, or actually I think the husband complained that the woman had remarried a African-American man and moved to a predominantly African-American neighborhood, and therefore she shouldn't keep custody of the children. And, of course, the Florida court dutifully agreed, which would tell you about what the attitude must have been down there at that time. But that's 1984. And I think if we all looked back, we would say, sexism is gone in 2014. Just as in 1984, most people would say, race is no longer a factor in the court systems, but it was. So I suspect as we look back over the next 20 or 30 years going forward, we'll realize that we were still making a lot of decisions on basis that really isn't permissible, which is the sex of the parent. A lot of fathers feel that they go to court for custody and they start with a leg down, and some people have a real chip on their shoulder about that. On the other hand, you can prove statistically, for instance, that in certain cases. Now, all things being equal, I can't believe, right, if a judge has 1,000 custody cases over his or her career, I cannot believe that in 920 of the cases, the mother was the better party, right? I mean, that can't be true, can it? I mean, are guys that bad in our society that only 8% would get custody? Or is there a bias? Well, that's another interesting question. Let's talk about statistical aberrations like that. When you try to look at what courts look at, and when people have gone to our Supreme Court here in the state and said there's a statistical aberration and this judge is obviously ruling wrong, or if we look at the sentences for this judge, and on average he gives black males 13% longer incarceration when adjusted for all other factors. Our courts have said, we don't deal in statistics. We don't look at statistics. One of the great examples of that, by the way, was when the Kids for Cash scandal was going on the other end of the state. It was brought to our Supreme Court's attention that there was this huge number of children, percentage-wise, from this one county going into detention. So if in the rest of the state, I think it was like 1 or 2% of all kids in the juvenile justice system end up in an incarceration or in a juvenile facility, in Scranton area, it was something like 40%. It was like 40 times as many kids in that county went to juvenile detention as any other. And it was brought to the court's attention saying, hey, something's wrong here. This can't be fair. This system is biased. These judges aren't treating these people fairly. And our court said, no, that's judicial discretion. We're not going to touch it. We're not going to look at or let a statistical anomaly like that cause us to look into anything. Well, statistical anomalies like that obviously have some basis somewhere. Something's happening that 40 times as many kids. Oh, guess what? It turned out that the judges owned, or at least were getting kickbacks from, to the extent they didn't own, the facility where they were incarcerating the kids. So the more kids they sent to jail, the more money they made. and magically you end up with 40 times the rate. My point coming back to this is, yeah, I think, and there are judges out there who predominantly give custody to women, and the statistical analysis will bear that out. Because again, I'm going to say, even if you give women a slight nod in the sense that when it comes to children of a certain age, so if you correct for that, and you say that, okay, well, we're going to say that infants, there's probably a better argument, et cetera, if mom's got her act together and she's breastfeeding and all this kind of stuff, then we have a better argument for mom to keep the kid. Okay, let's just talk about kids for school age or older and take certain judges' records, and you're going to discover that they definitely favor the mother. There's probably a judge or two out there that favors the father, but that doesn't even it out for the litigants, so to speak. It's not really fair. Now, the legislature did take a step and basically says that neither parent on the basis of sex has a presumption. What they didn't put in the legislation that some advocates of parents' rights, if you want to jump in and talk about this, it's 243-1200, 866-532-9466 or 697-4297, 243-1200. One of the things that they did not put in to the legislation, if think about it, would have been useful, is a presumption that custody between two parents starts at 50-50. They didn't put that presumption in there. They just said that there's no up or down for a man or a woman. A lot of people wanted to see it and just say, we start with the presumption that 50-50 custody is in the best interest of the child and work backwards from there. But that's not been done, and that's not been put in the legislation. I don't think they're going to revise the statute. Which, by the way, if you go to my website, romigerlaw.com, and you click on the Spreaker link on the front, we've got a bunch of old shows podcasted on there from this show. But I've also got a section called Carl's Commentary where I sort of talk about things. And I have a 10-minute, 15-minute segment on there where I go through the Pennsylvania Child Custody Statute and the 16 factors that are considered line by line and explain what each of those factors means generally and how you might want to think about it if you're preparing your custody case. The idea of that is just to get people's minds flowing, put you in a position to try to figure out what you want to do if you're making a custody claim or what you want to think about as you're putting your case together. And again, you can get that at the front of romigerlaw.com. It's on the radio link there. Oh, yeah, I want to remind you again about that Harrisburg Beer and Cigar event tomorrow at 1 o'clock. They're having a rolling. So is it Daytona 500's on tomorrow, isn't it?
This afternoon, we're carrying the Daytona Nationwide Series race. That starts as soon as my show's over at 1 o'clock. Tomorrow at 12:30, the Daytona 500 is right here on the radio station.
Right here on this station, yeah.
Exactly right.
Yeah, because that was that's what I was thinking was, it might be a good opportunity. They have a beautiful lounge over there, Harrisburg Beer and Cigar, and it would be a nice couple big screen TVs, a good place to watch the Daytona 500 while you smoke a cigar, or at least stop in and watch part of it while you smoke a cigar. A lot of guys aren't allowed to smoke cigars at home. I don't know if you know that or not, but these weaves, they get upset about something about the smell and the odor, and I smoke a lot of cigars, but I never smoke them in my car or my house or my office. And so I appreciate that fact. But my point on that is they have a beautiful lounge. They'll have some prizes going on, and they have Jay Castellon, who's a hand roller from York, Pennsylvania, who's a Cuban individual who rolls. Doesn't use Cuban tobacco, obviously. That would be illegal. However, they do have Cuban tobacco. I lied. They have Cuban tobacco from pre-embargo. So he actually has a series of cigars he did. There was a shop in Lancaster County called DeMuth's, which was the oldest tobacco store in the United States. And it's run by the foundation. And they rented where the space is owned by a foundation. But the people who rented it or ran it, the guy passed away, and the shop seems to be in limbo for the last few years. But they bought 4, I believe, bales. When I say bales, I mean like those giant bales of marijuana now. There's giant bales of tobacco.
Indeed.
So, it's one of these, it's a lot of tobacco. I don't know if they're half-ton bales or whatever they are, but it was tobacco that was brought over from Cuba pre-embargo, which makes it legal. So it's been aging all that time in a warehouse. which also makes it somewhat unique because, again, really old or aged tobacco. So here's my point. Someday they're going to run out of that because I know they sell it and they're going to run out of it. So if you stop over there at Harrisburg Beer and Cigar and check out Jay Castellan's line, you're going to find he does have a line of cigars which are made with real Cuban tobacco, which will be rolled by a real Cuban, but most interestingly, local to here in the sense that right out of York, Pennsylvania. So, and like I say, I do like their product. 243-1200, 697-4297, or 866-532-9466. By the way, Harrisburg Beer and Cigars on Union Deposit over there, if I didn't say that. I'm not sure if I mentioned, because sometimes people are confused, and I always want to say Colonial Park, but it's not. It's the next one down over by the Texas Roadhouse over on the East Shore side of things. Which, by the way, when I moved to Carlisle, I was so confused. 1995, and somebody says it's on the West Shore, and I'm thinking, boy, I didn't realize I was this close to the ocean. I'm going to go to the shore, and it's just a short drive to the shore. And then somebody says something about the East Shore, and I'm just in my head kind of trying to figure this out. I'm like, I don't think there's any oceans or things around here. Well, apparently people who live along rivers, because I never lived along a river, call them shores. Imagine that. And I guess it makes sense, right, because it is a shore. But where I come from, the shore is like going to the ocean. We lived on Lake Erie, and I guess we had the shore of Lake Erie. Who have I got? Bill. Bill, my friend, how are you?
Hey, great. I hadn't heard you in about a month or 5 because you changed times. I sure wish you'd go to 11 o'clock or something, but economics is probably the problem. My question is, what's the difference? I mean, I know the difference, but why somebody is called a suspect versus a person of interest? Once they're called a person of interest, they're as good as being a suspect. What's the story behind all that?
That's a good question. Calling a person of interest is a fine line. What the police are trying to say is, we want to talk to this person, and hint, hint, they may be a suspect, but right now they're just a person of interest. However, you could have a pure person of interest, okay? So I'll give you an example. Recently here in Carlisle, there was a shooting, and they published that this guy who owned the car was a person of interest. And that might be a pure person of interest in the sense that, you know, my car was used in a shooting, okay? So They want to know whether I was there or not, you know, and what I know about who I let drive my car. So that makes me a person of interest. If it's believed I was in the car at the time or driving the car at the time, that would clearly put me more in the suspect range. But I think sometimes the police may even use the word person of interest so as to cause the suspect not to become as alerted either, and perhaps consider talking with them and really going, oh, well, I'm just a person of interest, maybe I'll talk. But, you know, I've been in public places before where they you know, you hear, psh, psh, could Carl Rominger please report to the security podium? And my joke is, if you hear your name being requested to the security podium, send a friend to go find out why they want you. Don't go right up yourself, because they might not be letting you go. But yeah, person of interest, suspect, the exact parlance and why they would pick one over the other. Again, the absolute true person of interest would be, we have a video and there's a shooting and we can see clearly that this woman witnessed it, but that she went into a building and we don't know where she went. We don't know who she is, but we saw she had a pink umbrella and a white overcoat on, and she was at this block. And so if anybody knows who this woman is, she's a person of interest because she was the witness to a shooting, okay? So she's not a suspect. She's just a witness, so she's a person of interest in the investigation. So actually, maybe that's a better way of defining it, how they define who in their investigation is what. This is somebody we want to talk to, person of interest, because it will help our investigation. They may also be a suspect. They may become a suspect, or they may never be a suspect. But like you're thinking, a lot of times when you hear person of interest, you're kind of like, okay, that's the guy they're looking for, right? Scott Peterson is a person of interest in the disappearance of Lacey.
Do you got time for a little bit more? You got
go ahead.
Okay, following on that same line, they kind of bring you in for questioning, and you're definitely not guilty. You know that. But they start talking to you, and they get you all crossed up. So once you say, I have nothing to say, then they say you're not cooperating. So is it better to cooperate a little bit or just say, I have nothing to say? And your answer is, well, get a lawyer. But, you know,
anything you say can and will be used against you in a court of law. You have the right to have an attorney present during your questioning. Those are your Miranda rights, okay? And it finishes off with anything you say can and will be used against you in a court of law. Can and will. Not might be, not couldn't be, not wouldn't be, can and will. It couldn't have a harsher warning because it's actually probably a harsher warning than necessary in the sense that maybe everything you say won't be used against you, or maybe nothing will be used against you, and maybe you don't need an attorney. But you have the right to one, and you have the right to remain silent. But anything you say can and will. And so I always tell people, anything you say can and will be used against you. You have nothing to gain by talking to the police without talking to an attorney first. And a good attorney is not going to let you go in unprotected because the police can lie about why they want to talk to you. So what I would do, and what I do is I call the police and I arrange the meeting and I'm there and I control the flow of information. Because a lot of innocent people have gone to jail because they go in to talk to the police. So, you know, I get this one all the time. Guy gets accused.
You got time for more, or you got to go to somebody else?
Yeah, no, well, let me finish. I was just saying, I get that one all the time where guys go in to talk to the police to explain what happened. And their explanation's pretty good. But when they come out of the interview, the police remember it one way and they remember it a different way because two people having the same conversation will come to different conclusions.
Good. You got time for more?
Yeah, go ahead. I'll ride you out to the end, Bill.
Okay, and then I'll bring you to 11 o'clock because I'm half asleep right now just trying to get up to hear you today.
I'm still in bed. It's hard talking on your side, let me tell you.
On guns. I heard, and I don't want to shoot somebody even in my own house, and then I have to go to court and all that crap. So I heard somebody say that if you have a large can of wasp spray and, you know, it shoots out a big stream, and I know you're going to say just shoot them or something, but I'm just saying that I got a lot of cans of wasp spray in every car, and I got a gun in every car, but if I can shoot that wasp spray first and, you know, do it that way, I'll sure do it that way than go into court. So
yeah, well,
your help. When
I'm breaking into your house and you shoot me with the wasp spray, you better hope you knock me down good with it, because otherwise I'm going to get you.
Got you. Hey, keep doing what you're doing. Appreciate you.
All right, my friend. Take care. Oh my gosh, wasp spray. You have to hope that your attacker is a white Anglo-Saxon.
For people that bug you.
Back off, you pesky wasps. Oh, and Protestant too. Let's not forget. Oh, I crack me up. Don't forget to stop by RomingerLaw.com if you need to hire a lawyer. Obviously, we do take cases. And, of course, if you have questions or, you know, somebody throughout the week, I always tell people this. You know, if you come up with a legal question through the week or you talk to somebody, tell them about this show and tell them to tune in. And we get a lot of those callers where they'll be like, well, my aunt said to call in on Saturday, because the advice is free. So, you know, you can spend $75 to go to the lawyer and get a consultation. You can spend $100, $150, $300. Or you can call into this show every Saturday morning between 8 and 9 a.m. here on the WIOO and get a quick answer to your question and find out whether you really need to spend money on a lawyer or not. That's the way I look at this show a lot of times, is as a filter. You know, you tell me what your question is. I'll give you some general guidance and tell you whether you should be following up with a professional or not. But, of course, if any of these cases sounds like something that's important to you, or you think I gave an answer that will help you, make sure you do consult with an attorney off the air, because every case is different and a lot of facts are different, and a lot of information may change the final result. So I always throw those caveats on there. So make sure you stop by RomingerLaw.com. Go to Facebook and search The Carl Rominger Show if you want to follow the show online. We have lots of exclusive content there. We put it up every day. And I will see you folks next week at 8 a.m. God bless.
We play your favorites from the last 5 decades so you can listen longer. This is Country Gold FM, WIOO, 97.9. From the L.B. Smith Ford Lincoln Studios, this is Country Gold FM, WIOO Carlisle, and WEEO Shippensburg.
Joan Bennett. Things are moving fast in Ukraine a day after a deal was signed to end the political conflict and bloodshed that's left more than 100 people dead. President Viktor Yanukovych has left Kiev for his hometown, and lawmakers have convened a special parliament session to consider his ouster. One member of Ukraine's parliament says tensions remain high.
We are on the edge of a war, and the result of this war could be really horrible.
The UN Security Council votes later today on resolutions demanding immediate access to Syria's refugees. ABC's Kirat Radia with more from Moscow.
The UN Security Council is set to vote on a resolution to allow humanitarian access to Syria. But will Russia veto? Moscow remains a staunch defender of Syria's president, but the U.S. and its allies are hoping that Russia will at least abstain, allowing badly needed aid to reach desperate Syrians. The critical vote is scheduled for Saturday morning. Kirat Radia, ABC News, Moscow.
It's a tie for the lead in the overall Olympic medal count, 27 apiece for Russia and the U.S. Russia closed the gap by winning the men's parallel snowboard. More from ABC's Matt Gutman in Sochi.
There's one American here in Sochi who won 2 gold medals in these games. He's named Vic Wild. He won medals in snowboard slalom, but he's not competing for the U.S., but for Russia. He moved there a couple of years ago because he couldn't get the resources he needed to compete in the U.S.
Once again, the Midwest and East are cleaning up after high winds, twisters, and flooding ushered in by unusually warm temperatures. Severe flooding from Indiana to Pennsylvania. A Californian has died. 3 newborns have become ill after an outbreak of listeria linked to Hispanic-style cheese. 7 additional illnesses reported in Maryland. That cheese likely produced by Ruos Foods in Delaware. You're listening to ABC News.
Your Ford dealer checks a lot of things to keep your car healthy.
Synthetic blend oil change. Check. Tires rotated? Check. Brakes inspected? Check. Check routine maintenance off your list with The Works. Just $39.95 or less, minus a $10 mail-in rebate for $29.95 or less at your Ford dealer. Up to 5 quarts oil. Taxes, diesel, and disposal fees extra. Rebate by prepaid debit card. See participating Ford dealer for exclusions and rebate details through 3/31/14.
Now here's something you don't hear on the radio every day. Someone who can't see. I am totally blind. So I go through periods when I'm unable to sleep at night. And I feel like I'm constantly running, but can never quite catch up. But this isn't a sleep problem. It's something called non-24-hour disorder. Learn more about non-24 by calling 855-856-2424 or visiting learnmorenon24.com.
Apple admits a security glitch could allow hackers to steal user data over unsecured Wi-Fi networks. ABC's Ryan Smith with details.
Apple would not comment on how or when it learned of the security flaw in its SSL or secure sockets layer, or if the flaw was being exploited at all. On its website, the tech giant stated, quote, "Secure Transport failed to validate the authenticity of the connection." With millions using iPhones, iPads, and iPods, the worry that Apple's security problems may have only just...
Do you have a legal question you want answered? Go to romingerlaw.com. That's ROMINGERLAW.com. romingerlaw.com to get your question answered. 580 Carl Rominger here on WHP 580 and, of course, WLAN 1390. And I've brought a special guest on today. I have Dr. Arnold T. Scheinvold. And, Doctor, you with me?
I'm here.
Your practice, and so people who don't know, you are a PhD in
clinical psychology.
Right. But your specialization these days is quite a bit in the realm of family conflict and custody issues. Is that correct?
That is correct. General forensic, but especially in family conflict, custody evaluation work, anything to do with dysfunctions within the family.
And I will disclose I've had the pleasure of working with you in at least a few cases. I'm aware of your work in a lot of others, particularly in the central Pennsylvania area. How far does your practice extend?
Oh, in Pennsylvania, I have cases from Allentown up to Wellsboro, out to Chambersburg. I've had cases in Maryland and West Virginia and Virginia, and over towards Philadelphia. So it's a pretty wide area.
Yeah, that is a pretty wide area. And I imagine you see all different kinds of situations, both in and out of court.
I do.
Today, I want to focus just a little bit about a little bit of everything you do, but talk about the custody evaluation process, because that, for a lot of our listeners, we get a lot of phone calls about people who are engaged in custody battles. Mm-hmm. And notice I use the word battle instead of case. Guess it depends on the mindset. We have a lot of people that have high conflict cases. We have other people who have lower conflict cases. I guess from a lawyer's standpoint, this is what we tell clients, and I'll tell you, I would say to a client quite frequently, I think you need to get a custody evaluator. You need to get an evaluation done because a judge is just going to meet with your child for 15 minutes if you're lucky. Mm-hmm. Talk to the child for a few minutes and then try to get some input from a few hours of listening to the two parents argue over who's a better parent and somehow come up with a comprehensive custody plan. And I don't think a judge can do it in a hearing the same way that you can. So can you kind of help us out and tell us what it is you do to assist a court?
If we remember that in any of these cases, we're trying to figure out what's going to be in the best interests of a child. I mean, the standard in Pennsylvania now nationwide is a best interest standard. When we talk about a custody evaluation by a psychologist, we're talking about what are the psychological best interests of the child with respect to the relative parenting arrangements that can be put into place to his or her benefit. So the custody evaluator is attempting to gather as much information as they can through evaluative techniques and actually through investigative techniques as well to be able to answer that question or to make a recommendation to the court with respect to options as to what are the best answers to that question. And what you said is actually very consistent with what I talk with people about, you know, and you can answer this part better than I, but if you get a full-day hearing in a custody case, which may be the exception versus the rule given how busy our courts are,
right?
That's probably about 6 hours of actual court time.
Yeah, I would think that's about correct. In an 8-hour day with the type of breaks and also just the physical limitations, you know, people sometimes think that the court should go all day, but because of the requirement of a stenographic record, for instance, mm-hmm. The stenographer simply cannot continue to type all afternoon.
Right. In a custody evaluation, in a comprehensive custody evaluation like one that might be done here, one that I might do, we're putting in close to 40 hours of time with the family, which, if you compare that to a 6-hour day, is more like a 7-day trial.
Right.
And although there are certainly parts of the country where you get 7-day trials, you don't hear of it very often around here. So we can get a lot more information and then, in a sense, serve as a liaison to the judge with that information. And so it allows both attorneys to get much more of the information that's pertinent to the decision-making to the judge.
And actually, I can give you a kind of interesting little legal quirk here, which is the rules of evidence say that I have to authenticate a lot of evidence that I bring to court. Hearsay is generally not admissible.
Right.
And so in order to effectively present a lot of information to a court in a child custody case, either both sides have to stipulate to the admissibility of the matters, or you can call an expert witness like yourself, a doctor, and custody evaluator, and then you're allowed under the rules of evidence as an expert witness to testify about things that aren't generally otherwise admissible but relevant in your inquiry.
Correct.
And so that's the other, I think, as a lawyer, the advantage we see sometimes in bringing someone like you onto a case is we can now bring in material that would have been very difficult to admit otherwise without agreement from the other side, or just prohibitive time-wise again. And just like you say, you know, the court's not going to give me 3 days to drag in all different people to authenticate documents and to avoid hearsay.
Right, and that's really true. And there's obviously, like everything, there's a good and a bad side to that. When I'm allowed to report on what someone else has said to me, I'm allowed to report on it because I've relied on it in my report, but I'm not testifying to its veracity, to whether or not it's true. I'm just saying this is what I've heard and relied on it in my report. Now, obviously the judge can make that difference. I would agree that in some cases that's kind of a side door to get some hearsay testimony in. But I think for the most part it's done legitimately to really help the court get more information.
And I can tell you, I mean, that's the other thing I've told people. When you do have an adverse report, sometimes when people get a custody evaluator involved like yourself, we get a situation where we're not happy with the result. The client looks at you and goes, well, he's not recommending that I get primary custody. He thinks it should be split custody, and I don't understand. And the only avenue attack I usually tell people is, you can still have the full hearing, but great weight is usually going to be given to the expert's report. But that's exactly what you attack is, okay, well, let's look at what he relied on and what statements he took from people that we could prove are untrue, because some of your investigation isn't always to verify everything you're told.
Exactly. That's true.
And so that would be the best way, I would think, to attack it. But unfortunately, that is often not the case because I think generally, again, because of the length of time and the fact that I want to get back into this a little bit in the next segment here, the actual process of doing the evaluation, but because of the back and forth you do where you talk to some people and then bring them back in and go back and forth and gather information, it kind of self-verifies itself as it goes.
Well, a custody expert, a custody evaluator, has an obligation to get as much corroborating evidence or corroborating data as they possibly can. So what you're trying to do is get these different sources to give you data that converges on some sense of what the true data is. And every evaluation is going to have some data that disagrees with other data. You have neighbors who say the couple fought all the time, and then you might have a neighbor who says, well, I never saw them fight. But if you have 5 neighbors who are saying they fight all the time and one neighbor who says they didn't fight, then you have enough convergence of data. Then if you have psychological testing that says someone has an anger problem, and if you have, the children who you're interviewing saying, gosh, I hated when mom and dad fought, now you have a series of converging data that really helps you get a true picture of what's going on. And that's what's used in terms of assessing factors, and I guess we can talk about factors for custody in Pennsylvania now, but factors that are pertinent for the court in terms of making their decisions.
And those what do I want to say? Those concepts, like for instance, when 5 people say something, one person doesn't. It's kind of always the joke I've always said that if one person tells me it's going to rain, we don't know if it's going to rain. But if you hear it from 10 people, it's probably going to rain, or at least that's what the weather's reporting.
And the 11th comes in drenched, then you're
right, and then you're sure of it.
Right.
I'm going to take a break here. We're going to go to commercial for a few minutes, but I know, Dr. Scheinvold, you've said you're willing to talk to callers and answer some questions for folks. So the talk line number is 540-0580. Guys, this is your chance if you want to talk to an expert psychologist and maybe, kind of run something by in your own custody situation or how you feel, or maybe tell us a war story of an evaluation, or you always wondered why somebody said what they said or why they would do what they did in a custody evaluation. This is your chance. So 540-0580. We'll see you guys after the break. Welcome back. Carl Rominger here. I'm with Dr. Arnold Scheinvold with Riegler, Scheinvold & Associates out of Harrisburg, Pennsylvania. They have a comprehensive psychological practice, but Dr. Scheinvold is here talking about custody and custody evaluations with me today. 540-0580 if you want to get in on the conversation again. You guys know the number, 540-0580. This is your chance to, throw some custody questions at us if you're up for it. Doctor, when we took the break, we talked a little bit about just some general precepts. Tell me the process. I mean, how do you get involved in a case and what happens?
Generally, a case comes one of two ways. It's referred from the court, either through the conciliation process or from the judge themselves. And there has been a request for an independent, neutral examination or evaluation of the custodial issues. That's actually the best way to get a referral. You could certainly have the parties stipulate to getting a custody evaluation. They've gotten together with their attorneys, and with the advice of their attorneys have decided that a custody evaluation might help in the overall settlement process because there are certain questions that need to be answered, and perhaps if there was some reassurance around some issues or some clarification of issues that are causing some of the impasses and the conflict over parenting, if they had those answers from the evaluation, they may be able to settle the case. So that's another way it comes. In the past, it was not infrequent to have 2 experts involved, one who got hired by one side and one by the other side.
Right.
That's very much gone out of favor. because you get what's called dueling experts who kind of neutralize each other, and it's a difficult way to do a neutral evaluation. So that's becoming less and less common. The more common process is to settle upon a single expert who really is not advocating for either side, but simply trying to determine what's going to be in the best interest of the child. So that's the way the referral is likely to come in within that mode. Once the referral comes in, then different evaluators use different processes. If you're a psychologist, you're going to have to follow the guidelines of the American Psychological Association for child custody studies or child custody evaluations. And generally that means what you can expect, and I won't put numbers on this, but you can expect that all of the parental figures are going to have extensive interviews, comprehensive interviews. And I say parental figures because it probably will include step-parents or significant others in that process to get a full picture. You're going to have interviews of the children if they're of an age that you can have a conversation with them. You know, generally kids from 4 years up can be interviewed. Children younger than 4 can be seen, though, and observed and interacted with in some way. There'll be some observations made of the children with their parents, and that will be done and should be done to assess kind of the interaction skills and parenting skills that you see in them together, what their attachments are like, what the comfort is with the interactions. There will be the collection of collateral information. That could be doctor's reports, it could be hospital reports, it could be counseling reports, children and youth investigations, police information. Each case offers a different set of collaterals who might be important. It could be conversations with teachers or guidance counselors. It could be neighbors' input and information.
Does the court ever give you collateral information directly, like where a judge might write you a letter and say, here's my observations, or is that pretty rare?
The judge almost never gives you observations. It's I would say that's very rare, because it would be considered, first of all, the judge would be considering the case ahead of time, and it would be considered kind of ex parte, one-sided conversations with a judge. The judge would never have that conversation without both attorneys on the line. And quite honestly, one would have to wonder if the information is presented in some unusual way, there would be questions about the judge's possible bias in the case before he's heard all the evidence. So I would say that's virtually never going to happen. The only time that could possibly occur is, let's say there was an instance of domestic violence that occurred in the middle of a custody evaluation.
Okay.
You might then get a call and say, this is what's occurred. Could you also now, as part of your evaluation, assess dangerousness, impact on the child, whatever it may be?
Okay, interesting.
So I tried to give you kind of the breadth of information that we're trying to take in when we do this. Then there's a component of psychological testing. Obviously, if this is being done by a non-psychologist, you're going to see less psychological testing.
Right.
If it's being done by a psychologist, you'll probably see more.
Mm-hmm. Mm-hmm.
Almost all psychologists who are doing, and I say almost all because there have been surveys, there's national surveys on this, probably 85% of the people doing these use the Minnesota Multiphasic Personality Inventory, the MMPI-2, which is a pretty broad-based, what's called objective personality inventory, which helps screen for certain degrees of psychopathology and personality dynamics that might be going on in a case. Beyond that, there's a whole bunch of other psychological tests that might be used, but different people will use them differently.
Now, the criticism that I hear, and I don't mean it as a real criticism, but I'll hear people say, well, what psychologists really, there's nothing to that. They can't really figure out what's going on, and they really can't understand why somebody does what they do. And in my personal experience, it doesn't seem to be true. I would assume you would be similarly the same mind, basically, that you guys have some ability to do that.
Yeah, or else I'd be a charlatan, wouldn't I? If I sat here and said, we have no ability to do that.
Right, we have no ability.
I'm doing it every day.
Right, and I think that's why when we look at those reports, again, from the lawyer's standpoint, I've seen the reports, the inventories of people's personality, but I'm always most interested in what your direct observations and demeanor of the person are and what you think it means in relationship to the case.
If you think of this whole process as hypothesis testing, almost like a scientific experiment.
Right.
So some hypothesis is raised. Mom is trying to block the kids from seeing Dad, or that's one hypothesis. Or Dad has never been involved in the kids' lives and doesn't understand their personalities, or something like that, or their styles. You then test that hypothesis by gathering as much data as you can. So if you do direct observations and Dad doesn't know that his son is really interested in baseball and never talks to him about it, let's say. Or let's say that you get psychological testing that implies that this person has very little insight and is not very empathetic. And then you have neighbors who say they have never seen Dad outside kicking a soccer ball with a kid, and the soccer coach who says, well, Dad might come for the last 5 minutes of the soccer game.
Right.
That's what I mean by the convergence of data. So whereas no one piece of that data is saying much about Dad, because if I have a psychological test that says Dad has little insight, but then I talk to Dad, and he shows tremendous insight in the child, and he's been at every soccer game, and he is kicking the ball around with his kids, and all the kids love to jump on him and play and have a great time, then the psych testing is the outlier, and the other information is where the convergence is. So I've tested the hypothesis and gone the other way with it. That's what you're doing across the board with the various factors. Who's most likely to encourage contact between the child and the other parent. Mm-hmm. That's one of the major factors we have to look for in custody evaluation work. Well, again, using the same hypotheses testing technique, you'd say Mom either is or is not encouraging, and you look for the data that either supports that or not. And the same you would do for Dad.
And yeah, and I can tell you, just come back to that fostering the other parent's relationship with the child, I find that to be a difficult concept sometimes for some of my parents to understand. Others seem to understand. I've said it this way. I've said that a third of the people in divorces never even talk to me about custody. I'll say, do you guys have kids? Yeah, we have kids, but we've worked it all out. And they don't seem to have any difficulty figuring out a custody scheme that's going to work amongst the family. A third of them seem to need somebody to give them a little bit of a kick. And then another third seem to be in that high conflict area where they need an order, and then they need to be told how to follow the order again and again and again. But
actually, nationally, if you look at the studies nationally, it's probably 10 to 15% of parents are in that high conflict range.
Is that where they just make up a third of our work? That's
well, that's exactly right. But because remember how many people are figuring out their own custody stuff without any input from outside professionals.
Right.
So you're right in that you're talking about of the ones who come to you, it may be a third, and a third. But nationally, it's that 10 to 15% who really use up a lot of time of the courts and of professionals like myself because they need that kind of input. They are just so caught up in the conflict and hostility of the divorce that they can't work through the custodial issues or the parenting issues very well.
And I see. So then when I try to explain to them, you have to foster the other side a relationship with the child. It's for some people, like we said, we talk about this lack of insight. It just goes right past them. They can't conceptualize that that's something they're supposed to worry about. And I always find it fascinating. And so that's what you can do differently. I can just sort of be amused by the fact that they don't seem to follow, and frustrated that they goof it up in between hearings and don't progress. And then when we come back, actually, after the next break, I want to talk to you a little bit more about, what we do with people after we've kind of decided how to do the custody situation, and talk about some co-parenting counseling and some of the tools that people can use to make things work. Because that's the more interesting question is, can we rehabilitate? And one of the questions I'm going to ask you a little later is, out of this 10 or 15% that we're talking about that are high conflict, realistically, what percentage or what cohort can we expect to ever resolve? Or do some of them just have to resolve when the kids turn 18?
Well, we can talk about that.
All right. 540-0580. I'm here with Dr. Arnold Scheinfeld. By the way, doctor, if somebody wanted to get hold of you in your practice to potentially hire you for a custody evaluation or for work in some kind of family therapy, child therapy, how would they contact you guys?
Well, our phone number here is 540-1313.
Okay.
We're at 2151 Linglestown Road in Harrisburg. They can call anytime during the week between 8 o'clock in the morning and 8 o'clock in the evening, except on Fridays. It closes at 5, and there's always secretaries and receptionists available. And
we're gonna put a link up to your website on our weekendappointment.com as well as on romingerlaw.com and on a Facebook. So if people want to find it that way, they can as well. 540-0580. See you guys after the break. Welcome back. Carl Rominger here. Got Dr. Scheinvold on the line. He's talking to us about custody evaluations and how that works. If you're just joining us, we're now going to talk a little bit more about what we do to manage custody cases as they go forward. Doctor, was there anything else you wanted to tell me about the evaluation process that you thought people should know in particular?
Well, I guess the only thing I would add is that I mentioned it a little bit earlier. A custody evaluation, if viewed in a positive way, I mean, often it creates a huge amount of anxiety, and understandably so, because in essence, a parent is defending their abilities as a parent and often getting attacked from the other parent around those abilities, and it becomes kind of a negatively oriented event in that there are, some sort of allegations or concerns raised. On the other side of this, it really can be an educational event in which you have a professional who has a considerable amount of expertise in the area of parenting and what might or might not be best for children in certain contexts, offering up that advice for the parents to use or for the parents and their attorneys to use to facilitate really a flexible, dynamic parenting arrangement that really takes the children's needs into consideration in a much more individualized and unique way than they might get from the more blunt, cutting block of the court. So I think if one were to approach it more that way, it could be very, very helpful.
I've also seen in a few of the evaluations over the years where the evaluator is able to identify sufficiently individual issues with the parties, something that mom or dad might need to work on in their own psychological or spiritual health, and gives them a roadmap to what they need to do so that they can get back into the custody game, so to speak.
Oh, that's very true. I mean, it's very common for me in a custody evaluation to make multiple recommendations around either individual therapy that a parent could use to better understand certain aspects of their own personalities and how it affects their ability to work with their child or with their ex-spouse, or recommendations around counseling or therapy for kids who may be experiencing really difficult adaptations to their parent's situation, and that's really forcing the parent into having to take more difficult stances with their child at a really tough time. I mean, remember, we're seeing people, especially early on in this, not somebody who's 3 years down the line, but early on in a separation where these issues come up, we may be seeing parents at their worst rather than at their best. They may be enmeshed in anger over betrayals or perceived betrayals or perceived wrongs. Their own sense of stability has been undermined, and their sense of security is being challenged as they look at financial threats and legal threats and vocational threats in this. So it's very important that anybody working in the process, and most especially a custody evaluator, be aware of that, because given some time and some ability to just self-heal and allow time to heal it, this person may look very, very different 6 months or a year down the road.
Well, we just got and it wasn't from your office, but in a case I'm involved in, we got a report that basically, said one of the parties should take a hiatus from custody for 6 months while they work on some personal issues, and if they're successful with that, come back to the mix. That's not my client; it's the other client. I imagine that person probably, feels like, well, why would I do that? But I think that's what they were trying to say is you're having these major life issues of your own that need fixed, and dealing with the child as an additional stressor. But at the same time, you're all the bad things that are happening to you are rubbing off on this child when they're in your custody.
It's really a very difficult situation and a very complex situation, because unfortunately the court works in the moment. And in a very static way. So mom's going to have primary and dad's going to have partial, and here's the arrangement. Dad's going to see the kids every other weekend, and Tuesday and Thursday evenings till 8 o'clock, and sometime in the summer and sometime over vacations, whatever it may be. And it stops there. I mean, that is the arrangement. There's nothing that can be done in that arrangement that says in 6 months, let's see how things are going and see if we can move this forward a little bit more, because dad may have had some parent education training. And so, for example, we know from research that dads actually become better dads after they separate than during the marriage.
Right.
Because the roles that each spouse played in the marriage were based on the roles of the entire family intact. So dad may have relied on mom as the gatekeeper or as the primary nurturer or whatever, and was not as involved in things as he's going to become when he has to act as a single parent.
Right.
And that's like across the board. We see that as generally true, even though there's a changing dynamic in families now. But let's take the traditional kind of gender distinction. So we know dad is likely to become a better parent and learn more about routines and schedules and gatekeeping and appointments and all those types of things. But the court can't fashion a custody arrangement that way.
Right.
And if the parents can't communicate well and don't have ongoing communication, and if there's ongoing conflict, they don't have the mechanisms to make the adjustments, the flexible adjustments down the road as different parenting styles evolve.
Interesting.
So it's always a very complex mix that you're thrown into.
And I know, and that's what I'm going to want to talk to you a little bit about next, which is the ongoing, some of the concepts of, for instance, a co-parent counselor or co-parenting coordinator. But we do have a few callers popping up, so let's take a few of those here. Bill, you're on with Carl and Dr. Scheinvold.
You say Bill?
Yep.
Oh, yeah, this is me. Well, my wife, she currently is in a situation right now with her ex, and they're doing a parent coordinator thing. And right now he's trying to like get the parent coordinator off the case, and he does everything to try and manipulate everything. Back in a little while ago, the one daughter was living with him just for a couple of months, and then she was supposed to come back, and he held her and stuff for a long time when he wasn't supposed to. But what my question is, like, he continually, like today we get papers again, and he's contesting the parent coordinator. He contests everything. Is there any way to stop, like, having him keep doing this stuff, or it's consistent?
Do you want me to?
Well, go ahead. Go ahead.
I think the place to start, maybe for the listeners, is explain what a parenting coordinator is. Parenting coordination is a relatively new process that's entered the mix of alternative dispute resolution processes like mediation, introduced into the family courts. A parenting coordinator can be assigned to a case following the ordering of a decree, following a decree. So you get your custody order and custody plan, parenting plan out there, but there is so much conflict between the parents that they need someone who has the ability to facilitate communication between them and to make decisions in the event that they can't make those decisions. Now, the scope of the parenting coordinator's authority is often defined in the order that they get for that. But most definitely, a parenting coordinator cannot change the basic underlying custody schedule. So, if it's a shared custody schedule, the parenting coordinator can't make one of the parents primary and the other non-primary.
Right.
But what they can do is, let's say that mom's family is having a reunion on Sunday, and it's Dad's weekend. And Dad is saying, I don't care if you're having a reunion or not, I'm not letting the kid go. Rather than running to court and trying to get emergency petition and all the expense and all the time involved with that, they can go to the parenting coordinator who's been assigned to them, say, here is the conflict. The parenting coordinator can try to get them to agree to something different, but if they won't, the parenting coordinator can make the decision, and it will serve as an order, unless challenged in court, as to what will happen. So it's a process that is supposed to make life easier for kids when their parents especially are having difficulty making decisions together. So that's what the parenting coordinator is.
Yeah.
So
I mean, it's similar to what's going on right now. I mean, it's working actually, but
does he challenge the coordinator's determination a lot? Is that what's happening?
Well, he just did. Oh, yeah, he just did challenge it, and now he's like saying that she's pretty much incompetent and she's taking sides and all this stuff. And he got, I went out and got a lawyer for this.
Well, generally defined in the order is a way to grieve the parenting coordinator. And the only way to grieve or try to get rid of a parenting coordinator is what he's apparently doing, which is go back to the judge and ask them to be removed. But that would have to be with some very apparent cause. And the causes that might cause a parenting coordinator to be removed are clear bias or some other unethical behavior.
Yeah, I mean,
short of that, probably the best thing that can happen is short of that is you have a very supportive judge of the process, meaning parenting coordination process, and that judge says, no, I'm not going to remove. Now, the judge may also have the option of then saying, I'm going to assess all costs for this to the party who grieved unfairly.
Yeah.
And the key to parenting coordination working is, number one, having a good trained parenting coordinator, and number two, having a good, strong, supportive judge who basically says, you're in this process, stay with it.
And Bill, I got to let you go because we got to go to break here.
Okay.
So I guess the answer is hopefully it continues to work. And now if they keep dragging you back to court to test this, that's exactly what I would ask the judge to do. I'd say, Judge, you need to make it clear to the other side that they need to defer to this parenting coordinator and only make noise when it seems legitimate, otherwise face some sort of financial sanction.
Okay.
Okay?
All right, thank you.
All right, got to go to break here, guys. 540-0580. We're talking with Dr. Arnold T. Scheinvold, Ph.D., on child custody issues. If you're just joining us, and Tina, when we get back, we'll let you ask your question. Welcome back. Carl Rominger here, usually answering your legal questions, but today we're joined by Dr. Arnold Scheinvold out of Harrisburg area. Practices with Riegler, Scheinvold and Associates. They have a comprehensive psychological practice there, and he's answering questions for us. Tina, what do you want to ask the doctor? Tina.
Yes. I have a question. I had recently participated in a custody evaluation, and I was told and under the impression that it took 4 to 6 months. Ours took over a year, and cost a lot of money that I foot the bill for. And my question is, and when we received the evaluation, a lot of the information was not included in the evaluation report, and I just felt that it was kind of a waste of my time. We got nowhere, and we spent a lot of money on this. I also have a couple friends who have experienced the same thing. My question is this Are we in the minority, or is this something typical?
Well, I'll field that first. In my experience, I can only think of one time where I thought a report was somehow deficient. I can tell you that with Dr. Scheinvold, at least, any report I've ever seen of his is very comprehensive, and it lists what was relied on. But generally speaking, if you had counsel and I'd been your lawyer, I would have said, okay, what is missing, what's wrong here, and let's see what we can do to feed this back to the doctor or the licensed social worker, whoever's produced this document, and see how they would respond to that. And a year does seem like a long time to get your report.
I would say the typical length of time for a custody evaluation, a comprehensive custody evaluation, and so we go back to what I was saying, our process is earlier, is probably 3 to 4 months, maybe 5. And part of there's several reasons for that, or could be several reasons for that. When you're coordinating the schedules of all the people that I was talking about, that sometimes is problematic. So, for example, I might have a parent who tells me, well, I can only come in Mondays at 7 o'clock. So, therefore, my ability to see them becomes tremendously hampered. So scheduling problems can certainly arise. If there are important records that I need to see, you're at the whim of the people sending you those records, or you have to go back to the court and ask the court to order the records released, so that can slow it down. So there are a variety of issues that can slow it down. I would say part of the reason that at a minimum it takes 2 months goes back to something I said earlier, and that is that if you condense your evaluation to just a couple of days within a couple of weeks, you may get a person who's at a bad point in their life during those weeks and see a sample of their behavior which is not typical of them. And that can create a bias that you really don't want in the thing. Or on the reverse, you can get somebody who may be decompensating in some way, and they can hold it together for 1 or 2 days, but over the course of a couple of months, they're not able to do that. So that would be another legitimate reason for it to go out a little longer. I'll be honest with you, a reason that sometimes reports are delayed is one side isn't paying for it, and there's still money owed, and people don't write reports until the money has been paid in full. So the delays may mount, but a year is extraordinarily long. And I think the Pennsylvania legislature and the Pennsylvania courts have really tried to push to get cases resolved more quickly than that.
Okay.
The other problem you face with that long a report is you go into court and your data's a year old, and somebody says, "Did you know that Johnny now has been kicked out of school?" And so you have stale data. As far as not including stuff, at the very least, someone doing an evaluation should list everything they considered, okay, in the report. They may not then put any weight on it. So you might hand somebody a journal of all your entries since 2008, and they may say, I had a journal from 2008, but I didn't put any weight on it because it was kind of just a one-sided report of what happened. So that's what I can think of in terms of your question.
Okay.
All right, Tina, thank you very much.
Thank you.
In all deference to Tina, you also sometimes never know when people say, well, they didn't do much or they didn't include the right stuff. Sometimes that means there was an adverse conclusion they weren't happy with.
That's very true.
And I find they keep believing that if only the doctor had listened to this or would look at that, they would change their evaluation.
Yeah, there's a big difference between listening and hearing and agreeing. So.
Well, and I have the pleasure of dating somebody who has advanced psychological training, so I know you guys can make observations very quickly when you talk to somebody, and put together a lot of information that isn't obvious to the untrained eye. I've learned to cross-examine people, so I think sometimes I get a hint when somebody's saying something to me that it isn't consistent with something that they told me before. It doesn't quite ring true.
Sure.
And that's a skill that I've learned in the courtroom. But I know from dealing with the psychologists like yourself, professionally and personally, that you guys have a very different sense of perception of people's demeanor and why they're doing what they're doing, or at least possible reasons why they're doing what they're doing. And you talked about, for instance, like decompensating and holding it together for a while. And we've seen that. I actually saw that in a custody case not too long ago where the person held it together for, almost the entire hearing, but not the entire hearing.
Right. And that can happen. That's very, very true. I mean, the other thing that happens is not an issue with the custody evaluation, but I can get a custody evaluation in 3 months, but then they don't go to court for a year after that.
Right.
So then your data is stale, but not because you didn't get the report out in time, but because there were continuances and delays in the court proceeding.
There's a theory out there called case management, which sometimes works and sometimes doesn't. But I think if the lawyer's doing it right and the court's doing it right, you get these situations where sometimes the court says, we won't schedule a hearing until we have a report.
Right.
And you want to say, Judge, can you hold with me a little longer? Or you're done for the hour?
Me?
Yeah.
Oh, no, I can stay a little bit longer.
Yeah, hold over to the second hour here, because I really think people want to hear this. We're getting a lot of feedback. Even though we're not getting a ton of calls, we're getting a lot of feedback.
Okay.
All right, hold on.
All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon again, guys. Carl Rominger here, 540-0580, the talk line number. And if you were with us the first hour, you know we have Dr. Arnold T. Scheinvold, Ph.D. in psychology, talking with us about child custody issues and child custody evaluations and co-parenting coordinating and all the other things that intersect with the court system and custody cases. And the doctor was good enough to give us an hour and then stick with us a little bit longer. So thank you, doctor.
You're welcome.
I think we were talking about, and I'm trying to remember exactly where we were, but the concept of the co-parenting coordinator and the things you can learn from the report, and talking about when you just talked to somebody who wasn't happy with what was in the report. And I guess I was going to say, and she was unhappy about how long it had taken. So the setup being is, I was just saying when they so rudely interrupted us with a commercial break that I guess we have to have those, that sometimes the problem's case management. And so you say to a judge, I want to have a hearing. And the judge says, well, I'm not going to schedule the hearing until the report's done. And then the judge gives you a hearing that's 4 or 5 months out. And then this creates this staleness issue in the results that you've created.
Right.
I think sometimes it takes a lawyer to remind the judge, and sometimes in a written motion, hey, judge, we like that plan, but why don't we do this? Why don't we wait? Why don't we get the process started? And as long as everybody's paid their deposit and we get confirmation from the doctor that the process has started, you pick a date and put it on your calendar. And then about a month ahead of that, we'll make sure the report is either complete or will be complete. And if it isn't, then we'll move that date. And I think an aggressive lawyer can help manage that a little bit when you do have a judge or a court administrator who isn't sensitive to that issue.
It also, and actually in support of that somewhat, and I don't want to shoot myself in the foot here, but it also puts pressure on the evaluator to make sure they stay on top of it and get it done in a timely way.
Let me ask it this way. I'm a professional. This is what happens. I come in the morning, I look at my deadlines, and they've got to be done first.
Right.
And then we can get to the stuff that isn't deadlined. And so the joke is somebody said, why do you lawyers always do everything at the last minute? And we're like, well, because that's when it has to be done.
Right. And, we're working in a system that is a very clogged and busy system. And every day resources within that system become less because of budgetary concerns.
Right.
And so there's really a combination of factors that create some of these problems.
I also have and this kind of goes to the theory of, where should we really be investing? And unfortunately, the court system seems to invest a lot of its time. Everybody thinks that the court system is clogged with personal injury cases. And it really isn't. It's clogged mainly with criminal cases, family law cases, and business-to-business litigation. Mm-hmm. Can't do anything about the criminal case. I mean, we have to deal with those. But taking resources away from the family law arena is, in my mind, not a good long-term solution, because I think if courts are creative and we get involved and we intervene a little bit in some of the high conflict cases, we can probably prevent kids from growing up who have worse outcomes. And I think, you correct me if I'm wrong here, but a child whose parents cannot get along in a split custody situation and who cause grief for the child probably hurt their development in a way that causes higher likelihood of criminal behavior, less employability, more long-term psychological impairment, etc.
One of the most robust findings in the research on children of divorce is that children who are exposed on a consistent basis to the interparental conflict, and especially if it includes physical conflict, have more problems with depression, what's called internalizing and externalizing problems. Internalizing problems are worry, anxiety, depression. Externalizing problems are acting out, aggression, drug abuse, alcohol abuse, sexually acting out, teenage pregnancies, those academic failure. So that is, if there's no other finding you want to believe in the research, that's been replicated hundreds of times, that the interparental conflict and hostility, the more open it is and the more severe it is, the worse the results for the kids. So when we talk about the very high conflict cases, those are the kids who are most vulnerable. The other interesting comment in society, I'll make it, but
right.
Don't want to get lost in it, is that we tend to invest more money in business litigation, the court's taking time for business litigation and criminal court than for families and kids. And there's just something fundamentally wrong about that with respect to value.
Well, and it's interesting you point that out. So you say, you're talking about how hard it is to get a custody case that's more than a day. In Franklin County, Pennsylvania, they've been pretty good about giving multiple days, although these days their court calendar has really been crunched with criminal stuff. And of course, now they've even kind of rolled back, I think, their willingness to do 3- and 4-day custody trials if the parties ask. Mm-hmm. But in the meantime, you can come in on a medical malpractice claim where, somebody's fighting over, a couple $100,000 in damages for something that's already happened. And they tell the judge they need 3 weeks to try it, and the court says, sure. And then you come in with a murder case, and you say, we need 2 weeks to try it, and the court says, can't you get it done in a week? And then you come in with a child custody case, and the judge gives you a day, but then informs you on the day of trial that he's decided that he can only hear the case until 1:30 in the afternoon, so just call your 3 best witnesses. Mm-hmm. Not good.
I totally agree with that. But that's, of course, also then why judges rely more on the custody evaluator.
Right. Which is why, again, and of course, this comes to that next cost, next problem, which is we don't really have a system for people who don't have money to access this system very, very easily.
There's a lot of discussion about a 2-tiered legal system in the United States, and for the haves and the have-nots. And there are many states that have court-connected services. And court-connected services mean there's an evaluator in the court, or there's a mediator in the court, or there's a parenting coordinator in the court, who is a court employee. Mm-hmm. There are a couple of venues in Pennsylvania that have some of those services, but for the most part, the state does not have court-connected services or court-annexed services. That would certainly help with that problem. We don't have that, and so we all have an obligation to think about how to solve it.
Right. Now, let me see. We'll take a couple callers here. Joe, you're on with Carl Rominger and Dr. Scheinvold. Joe.
Yes, this is Joe. Thank you for taking my question. I might be veering a little bit away from the topic, but I'll ask my question, listen for the answer to the doctor. I was just wondering what the requirements are to become a coordinator or evaluator and what the demand in the field was. Thank you.
Okay. To be you're talking about two different things there. Generally, there are requirements within the profession itself that may be expected. But the truth of the matter is the court defines who an expert is when you come to a forensic case, not necessarily the profession. So there are certain model standards out there. So, for example, the Association of Family and Conciliation Courts has model standards and includes the areas of specialization that a person should have who's doing a custody evaluation. So they should know family dynamics, they should know how to utilize psychological evaluations, psychological testing, they should have expertise in interviewing children and adults, they should have an understanding of how psychopathology affects parenting, those type of things. With respect to parenting coordination, there are guidelines that have been put out by both the American Psychological Association and the Association of Family and Conciliation Courts. And within those guidelines, they are saying that a PC should have at least a master's degree in mental health field and or a JD. Although parenting coordinators can certainly be community volunteers. But then it's a matter of having the training necessary, and they should have training in mediation process and mediation skills, and then all those things I talked about with respect to the specialty areas for child custody evaluators. They should also have an understanding of those things, and finally have an understanding of arbitration procedures, since they'll be decision makers as well. I don't want to go into a whole long explanation of competencies, but I would say that's it. There is no specific specialization of child custody within the profession. You generally might specialize in forensics and then get specialized training beyond that.
Interesting. So what we're going to go to break. Doctor, can you hold us a little longer? I mean, I'll take you all the way to 3:00, but you probably have stuff you want to do.
I really I had only thought I was going to be an hour, so I need to leave here by about 25 after 2.
Okay. Yeah. As soon as you need to go, just jump. I know a few more callers. I'm going to take a quick break and then we'll take them.
Okay.
Hey, guys, talk line here is 540-0580. But if you need to get hold of the doctor, and if you think you need some kind of psychological services, particularly, and it's a comprehensive practice, but we've been talking about the child custody and family therapies, 540-1313. That's the right number, right, Doctor?
That is the right number.
Yeah, 540-1313. And I also just put a link to his website up on my Facebook page, so you guys will be able to find it there as well. Doctor, I want to let you know, besides all the calls, we've been getting a ton of Facebook traffic, people just saying how interesting this is, and so you're a big hit.
Well, thank you.
Denise, you're on the air. Denise.
Hi. Sorry, I didn't hear you. My daughter is in a bad situation. Her husband's very emotionally abusive. They have a 5-month-old little boy. She wants to leave the situation, but the husband said he will definitely go for joint custody. Now, she has gone to work, and he has called. He watches the baby when she goes to work. He has called cursing and swearing. The baby's crying, and she's had to leave work, come home. We have all this documented. And she went to the movies the other night with a girlfriend. He's cursing and swearing, saying she needs to come home. He can't take it.
Well, let me stop you for a second.
Mm-hmm.
I always love when people say they don't want to leave because he's going to go for custody. Well, right now he's got joint custody, right?
Well, yeah.
So it's not going to get any worse if she leaves in that strictest respect.
Well, she's afraid that he has never kept the baby overnight. I mean, he will not do anything with the baby as long as she's there. And he's never given it a bath. He's never given it baby food. He's never done anything other than give it a bottle and change a diaper.
Right.
So she's scared to death that if she leaves and it goes into a custody thing, that he will have the baby regular custody time and not be what she feels, a fit father. So we did see a lawyer. We had all this documented. The lawyer didn't even want to look at the document. She says if he pushes joint custody, they will give him joint custody. And the best you can hope for is that they will send him to parenting classes, say he's a new dad. And she said, well, he says he hates his life. He wants to die. And they said, well, they'll just put him on antidepressants, say he's depressed. I mean, everything she thought she had seemed to close doors on her. So she feels kind of stuck. She doesn't want to share time with a father that really shows only interest minimum in the baby.
But that's and I'm going to answer for the doctor, I think. Didn't you tell me earlier, doctor, that one of the studies shows that upon separation, a lot of the dads get better at it?
Well, dads do get better. The studies do show that. Part of my answer to this question would be, number one, It might depend what jurisdiction you're in as to what judges or conciliators might do in the situation. But in Pennsylvania, there is no presumption of joint custody, meaning that there is no understanding that when you go in the court, it'll automatically be joint custody, meaning
the judge
equal custody.
or the lawyer pretty much made us sound that way. That, and the baby's breastfed, and the lawyer said that they will tell my daughter to wean the baby so that he can have custody.
Well, it depends what you mean by joint custody, and oftentimes what happens is there's a confusion of terms. If you mean will the dad be able to get some overnight time with the child, but maybe not equal to the mom? And if you consider that joint custody, then yeah, there's a good chance of that. There's a lot of debate out there about whether young children should have overnights away from the primary parent. But I will tell you, the research is very ambivalent and very uncertain as to whether that's good or bad. There's research that says it can create insecurity in the kids, and then there's research that says it doesn't do that at all. And if we look at real-life situations, it's not uncommon for 5-month-olds to spend an overnight with a grandparent, for example, while the parents go away for the weekend. So it's not that kids can't be away from their parents at all. I think the situation would need to be evaluated on the factors you've mentioned. So is somebody verbally abusive? Are they so unskilled at this point they need some parent education prior to getting to the point of overnights? And you need an evaluation of that. You wouldn't be able to just make that assumption based on what's called he said, she said evidence.
And Denise, I'll also tell you that having done many custody cases over the years, I sometimes find that no mother wants to part with their baby under any circumstance, even in a intact relationship. The first time they leave the baby with the grandparents overnight, they're freaking out. So you kind of have to sort out what's real and what's imagined, and also recognize that if the guy does step up to the plate, the courts are probably going to let him attempt it. But exactly how that'll play out, I don't know. I'm going to let you go because I want to take one more caller before the doctor has to go here.
Okay,
Thanks.
you.
And Lisa, you're on with Dr. Scheinfold.
Hi. My question was actually, I wanted to know how old a child needs to be for any form of psychological evaluation or meetings to actually be effective or useful.
Depends what you're evaluating. If you're actually evaluating the parent's competency, you could have a 4-day-old infant, and you're trying to decide if a parent has the skills or ability to care for a 4-day-old. And maybe the parents need some parent education around how attachment is developed and how you maximize the ability of the child to attach to parents who aren't living together. But if you're asking how old does a child need to be evaluated for their own psychological health, there are individuals who do specialized infant evaluations looking for developmental aspects in their behavior that they can begin to assess what's happening in terms of cognitive development or social development and whether there are delays in that.
Okay. As I have a 4-year-old and a 1.5-year-old, both boys, they live primarily with me, but they only go to their fathers generally on the weekends, which they do spend overnights over there, sometimes 2 nights in a row. There's no actual custody arrangement, so everything is just the way we decide right now, mostly how I decide. But I've noticed serious reactions from both children when they come home sometimes, and I've been really concerned about how well they're being taken care of over there. I know for one thing that the diapers are not being changed well, because I send a child over for 8 hours with no diaper rash, and they come back consistently with one. That much I know is at least going on. But this last time, something was very wrong. He was clinging to me like he's never done in his entire life. He
being which one?
Terrified to get in the crib, the 1.5-year-old.
Well,
and he, of course, can't tell me what's happening, and his brother isn't really quite to the point where he can fully explain to me what's going on either.
Remember that children go through normal developmental stages. so that a child who at, let's say, 13 months old was not showing much reaction, at 18 months old might be showing reaction because they're going through kind of a second stage of separation anxiety.
Okay.
And so you have to sort out that which is normally developmental, along with the fact that all people, and children in particular, get moody around transitions, and these are transitions the kids have to make. So I think it might be helpful as a starting spot for you to talk to your pediatrician about normal kind of developmental stages like that and see if some of it can be attributed to that. I mean, diaper rash can't be attributed to that, but certainly some of the transitional aspects of mood could be.
Okay.
Okay?
Yeah, I was so concerned this past weekend that it made me start wondering about it.
So Lisa, I think you should follow through with that and see where it goes. And then if the concerns continue, then you might want to, take it to the next step. But I would work with the pediatrician.
Okay. All right. Thank you.
Doctor, I know you got to go, so I want to thank you so much for coming on and helping us. People are very, very interested in this topic.
Well, it was very much my pleasure. If there's another time to do it, we'll do it another time.
Yeah, we definitely would love to have you back. There's no doubt about that. I can tell you that the call volume has just continued to build. Like I said, we're getting tons of feedback. People are very. This is one of these areas where it's kind of there's a mystique to it. People go to custody court, and lawyer and the psychologist and the judge are kind of chopping everything up and then telling them what to do. And I don't think a lot of times they understand why the court does what it does. Now, hopefully, they have a better understanding of why you, as the custody evaluator, do what you do.
I hope so. Hope it helped.
All right. Well, thank you very much. Again, if people want to get in touch with you, it's 540-1313 to get to your practice. And basically, you guys can help people with all different sorts of issues involving family law.
There are 12 different therapists and different professional backgrounds up here.
And I do have a link to your website up on our Facebook, and we're going to put it up on the other show websites. So hopefully people will follow up. And if you do go see the doctor, make sure you let him know you found him here on the radio so he knows it was worth his time. Definitely worth ours.
It was worth my time one way or the other, so thanks.
Thank you, doctor.
You're welcome. Okay, bye-bye.
Bye-bye. Yeah, you can't beat that, guys. I mean, you get a real live expert like that who does this, who parses these things to help us out. I wish more of you had been able to catch him on the phone. Rob Culling, how are you?
Pretty good. How's it going, Carl?
Good. Were you able to catch any of the doctor?
A little bit, yeah. Very interesting and very, very important for folks to know when they have custody questions about, especially about custody evaluations, risk assessments, mental health evaluations. It's very important for these folks to know this going into it, what they can expect and what they think they might need.
Yeah, and I think we only touched the tip of the iceberg. We were it felt like we filled up an hour and a half, and half an hour of it might have been with callers, but an hour of it was just discussing in general the process, and I don't feel like we even got that specific. That's just how much stuff there is out there in this area and how complex it really is. But I think the doctor did a good job of helping people understand that, and I thought this was very fascinating. Basically, you're going to get 40 hours worth of court time packed into an evaluation that you'd otherwise have to do 7 days of hearings to get the equivalent in front of the judge. And so, and people go, oh my gosh, that report's going to cost $3,000 or $5,000. Well, guess what? 7 days of a lawyer in court. Let's just assume that the lawyer is going to bill $150 an hour, 8 hours a day, not going to do any prep or anything else for the case, right? And we're already at what is that? $1,200 a day times 7, $8,400. And then if we add on the prep time, et cetera, we're going to end up with a $15,000 bill most likely.
Right.
So all this only $5,000 is 1/3 the cost, and quite frankly, you're getting an expert, not just a knucklehead lawyer, putting all this stuff together.
Right.
Rob, can you hold with me for a little bit?
Sure.
Guys, if you don't know Rob Culling, he practices in my office, and Rob actually does a general practice. He does some adoption, some family law, some custody work, as well as a host of other things. But he's going to hang with us and answer questions for the next half hour. See you after the break. Hey, welcome back. Carl Rominger here. Well, we were doing the custody show, and now we'll just keep taking legal questions for the next half hour or so. I'm joined here by Robert Culling in my law office. And, if you ever call in and you can't get me, Rob is also available, and that's part of the reason I like to bring him and the other lawyers on the show so you folks can talk to them. I would obviously not hire somebody unless I was willing to let them represent me. Let's see. Who's our next question here? Megan, you have a question?
Good afternoon.
Yes.
Hi. I just had a comment basically in response to the last lady who called. I believe in fair custody. Men can be just as good as parents as women. But I was through this 20 years ago with my children with a very abusive in every way spouse. And no one wanted to listen to what my children had to say. The children and youth people brushed it under the rug. They refused to deal with it. And we were ordered to go through this court-ordered evaluation thing. And I'm not passing judgment on any professional, but I'm telling you, it was just a nightmare, and my children suffered so terribly because no one wanted to listen to what was really going on and their suffering. And I guess I would just encourage. It just really made me angry. Of course, every time your child cries or has a nightmare, you don't say, "Oh, I'm going to blame it on the ex because they were
Right.
just visiting." But you've got, whether you're a mom or a dad, when something out of the ordinary, uncharacteristic happens with your kids, you've got to listen to your gut, and we've got to protect our children.
I don't disagree with you, and I go back to the diaper rash for a second. I'm thinking, if you really do religiously change diapers, you very rarely get a diaper rash, for instance.
True.
So the mere happening of one alone doesn't mean somebody's a bad caregiver. But if it's chronic, it's either and if it's only happening in one household, then I think it's pretty self-explanatory. I know everybody has different standards. Some people use the same bath towel for a week, and some people use a fresh towel every day. And I'm still using the same towel that I had in my dorm room in college. So the long and short of it is everybody has different standards. So I can see differences there, but there are minimum cares. Now, when you talk about potential physical abuse or psychological abuse of a child, and you're not there to observe it. And then again, kids don't articulate these things well. They're afraid to tell the other parent. They have crossed loyalties. There are so many issues involved in that. And but then the flip side is, as often as there is something legitimate going on, when we get into these subset of high conflict parents, that 10 to 15% we were talking about, we get frustrated in the court system because they will find everything to be some symptom of unknown abuse that nobody else will recognize. And if only we would listen, we would know about, and we could, they could prove it, but just nobody will listen. And so, unfortunately, those people do as much harm to everybody else as they do to their own families, because it causes judges and lawyers and sometimes maybe even psychologists to become a little more skeptical than they should be when something legitimate is going on.
Right.
And
right.
So it's so complex. There's so many moving parts, but your comment is very well placed.
It's just got to be from our courts to everybody. They just need to drop the political BS that goes on. I come from a small county, so it was that kind of mentality, and I bucked the system. And over my dead body, were my kids was it going to continue, and it's just any good parent is that way. And so I would just encourage, I'm not downing anybody or anybody's profession, just, your children, and if they're not safe, if you're not going to stand up for them, who will? And we as a society need to say, that kind of behavior and mistreating children, it's wrong, and there are consequences for it.
All right, Megan, appreciate it.
Thank you, Carl.
Thank you. 540-0580. Stephanie, you're on with Carl and Rob.
Hello?
Hello.
Hi, yes. I have a question for you. I started working at a hospital in 2008, and one of the things that they offered was a scholarship program for the nursing school I was going to. And it was very attractive. It said, we will pay, and then you have to pay us back by 1 month's service for every month of the scholarship that we provide for you. And they provided 8 months for me. So I graduated from school, and they kind of put me off for a little bit for a job, played around a little bit. I waited a year, and then they put me into a nursing position.
Okay.
It's an odd situation, but at any rate, I was actually let go. That was the phrase they kept using, let go. And so I went out and I searched for other jobs, and I applied for unemployment. I was granted unemployment because it had been an extremely hostile work environment, and it was determined by labor and industry that I had done the best I could. I was always there on time, etc. Well, I just got a letter from them. They contested my unemployment, and then when labor and industry decided that I did earn the unemployment, they sent me a letter from the hospital.
Right.
And I believe it's punitive, and it says, oh, hey, you only worked for 5 of the 8 months that you owed us. Now you have to come up with $4,700 and some in 30 days.
So they're trying to get money back.
Exactly. Now, the terms of the contract I signed address things like, you have to do the job, you have to, maintain your standards and everything. The one item they do not address is involuntary termination.
Yeah, so what we'd have to do is read the contract very specifically, and then determine what our best position is in terms of what it really says and whether you actually owe the money back or not. And that's what happens. They'll take a position, you'll take a position, and maybe either side will persuade the other one to blink, maybe settle it, or ultimately have a court resolve it. But that kind of contract interpretation that you're asking for would require us to actually sit down and read the contract.
That's fine.
So why don't, if you want to call our office, it's 241-6070, 241-6070. You could ask for Rob Culling.
241-6070.
Yep, Rob's been listening in, so he'll be familiar with it when you call.
Absolutely.
And he can read that over and try to come up with an interpretation. Listen, I notice I say interpretation, right? It reminds me I had a client who wrote a contract in Chinese with another Chinese speaker. And, of course, when they both translated it, they both came up with one word different. Right. And it was the word that made all the difference, right? The other lawyer and I are kind of looking at each other like, well, who knows, right? We'll have to get an official translator to tell us. And, of course, then we found out that that word could mean both those words in English. Yeah. So it was even worse, right? So then you really got to try to figure out what was going on. But my point is everybody can take a position on what they mean in a contract. The court starts with the plain language and works backwards from there. But we have rules on how to do that. All right?
Okay.
Hey.
So what should I wait till Monday to call?
You can call Monday's fine. Yeah.
Okay.
All right. Thank you.
Great. Thank you so much.
Not a problem. 540-0580. John.
Did you say John?
Yes.
All right. Good afternoon. Love you guys' shows. I can't wait for it to go to 3 hours. Here's my question. 7 years ago, approximately, I had a full septic system put in. Recently discovered that what it looks like is one of my pumps down at my sand mound is dead. I had multiple plumbers come in and contractors, septic people, etc. And there was a reoccurring theme with some of the ones that had been around a little longer. And they point to the fact that what wire size had been run out to my pump. They started talking about voltage drop over length of wires, etc., and how it can be bad for pumps, and basically it will destroy even the best of pumps over time. Now, I know that the National Electric Code has recommendations. They have fine notes, as they call it, but it clearly says in one of the sections of electrical code, which I've been looking up, requires equipment to be installed in accordance with the equipment instructions. Therefore, electrical equipment must be installed so that it operates within its voltage rating as specified by the manufacturer. It's clear. You can do the online calculators. You can follow Ohm's law. It's nowhere near what it should have been, probably leading to my pump failure, leading to a new $800 pump, the digging, the sand mound being clogged, etc.
So
do I have any recourse?
You can sue. Now, how long ago was this installed?
7 years.
7 years. So what we'd have to look at is you just realized the problem. So it's from the time you realize the problem that matters. But then we have what's called the statute of repose, which says you still have to bring a claim for some kinds of construction and other things within a certain time period, no matter what. Not sure what the statute of repose is on that. What I would recommend you do, again, if you want to call in the office and check with Rob, we can probably do a little preliminary research for you. It costs you a couple $100 and give you an idea. But basically, I think you would have a lawsuit at this point. The real question is then the person you would sue, do they have assets that you can collect?
Well, they own an excavating company.
Right. Well, that's point one. But how about this? How about they own an excavating company, but they're married, and all their equipment is leased to the excavating company by the marriage, and their home and all their other assets are marital, and then you can only reach the excavator, and he doesn't have any assets.
Kind of like signing a tenant agreement with a landlord, but everything's in both their names, so when he does you over, you can't go after anything.
Yeah, you've been there.
Yes.
So, on the other hand, though, all the best laid plans sometimes end in divorce, and then everything gets split up between the contractor and his ex-wife, and then he's not judgment-proof anymore. So, a lot to look into there, okay?
It's fair enough. It's enough for me to consider more than.
But you definitely have some.
How to get a hold of you guys?
241-6070, 241-6070, or go to romingerlaw.com.
Already there.
I got to go break, guys. We'll be back. All right, welcome back, kids. Now, first of all, I got a text here I'm supposed to read to you. One of my friends/clients said, I was going to call and thank you for helping my case and to tell people you're the real deal, but I'm a bit shy on the radio. We'll read my text. Thank you. You wanted me to read on the air. So, yes, I did get your text, and I really appreciate it, and I do the best I can, which is sometimes means I lose, but it is a good effort anyhow. 540-0580. I also want to give a special shout-out to my girlfriend, Hillary, and just say what a special woman she is. I talked about her a little bit in the first hour, so I just owe her that, I'm sure. But she's a lot smarter than I am. So anyhow, Kevin, you're on the air. Kevin.
Oh, hello. I'm sorry, Carl. I didn't realize you'd talk to me.
Yeah,
thanks. I hope you can help us with our problem.
Yes.
We have grandchildren with my wife's son's family. And due to just a nasty attitude and behavior, we've been cut out of their lives. And before, my wife spent a great deal of time with them, and she just decided that she wasn't happy with it anymore. Not my wife, the daughter-in-law. So I'm wondering what kind of rights we may have as grandparents to be able to see our grandchildren.
Well, Robert, I don't know what you listen to this and tell me whether I'm right or wrong here.
Okay.
I would think that the children are an intact family. In other words, it's the in-law and the child. Yep. And so you're not going to be able to activate any of the grandparents' issues where, one of the parents is dead or one's a drug dealer and in jail, one of those issues. Now, the next question is, did the grandchildren ever spend any amount of time living with you?
No.
Okay, so you're not going to be able to get under the other subsection that says, that where a child's lived for more than a year in the grandparent's house, with or without the parent, there's an automatic right of visitation, not custody, but visitation. So, Rob, did you see any other standing for them?
With that scenario, I'm not really sure that it doesn't seem like there's a position where they could take as if they were acting as a parent. Like you said, there's no risk of harm to the kids. The kids don't live with them. I mean, especially with the new laws here in Pennsylvania, there's a significant hurdle for parents.
Grandparents.
Grandparents, sorry about that. Yeah, and so they might be in a position here where
now
they might be deadlocked, but that doesn't mean they can't come in. I can go over every factor with them, talk to them about it, see what maybe there's something that we can do.
And the other thing is, I call it the bluff, but sometimes even if you don't have any standing at all, you write a letter and you say, "Hey, I'm taking you to court, and I'm going to try, and here's my here's my thin angle that I'm going to argue that I'm making." And the other side goes, "Well, And then the other problem is, you may be having a problem where your son, for instance, may not really realize what's going on."
Yeah, he's very well aware of it, but he's not willing to give up his standing in the house to go against her.
So maybe he needs some leverage. Listen, honey, I understand you don't really want to do this, and I'm not really not backing you. I'm just pointing out that it's going to be very expensive for us to fight this. Or, you may give him some leverage to help reverse the dynamic. So that might be how the threat of a legal proceeding could change the dynamic.
Yes, I believe you're right. If we went against her, it's not going to help us to use him as a lever.
No, but
he's backing out of the situation.
But it may cause him to go. Wait a minute, my parents are actually suing me for custody. What's going on?
Yes.
Yeah.
I see what you mean.
The other fact is that you actually have to sue your son as well as the
you can't. Yeah, for court action, you got to go against both of them because everybody with a right to the child would have to be noticed.
Correct. So we would contact you at carlrominger.com?
Yeah, just go to romingerlaw.com.
romingerlaw.com,
Yep.
Okay.
All right, and then Rob's familiar with the case, so he'd probably be happy to help you.
Absolutely. Okay, very good.
All right, take care.
All right, thank you very much.
Not a problem. 540-0580. Tony.
Hi, Carl. How are you?
What's going on?
Good. Hey, I have a lady who sued me with a civil suit about 6 years ago. I sold her a house that I owned for about 1 year, and I never had water in the basement. Sold it to her. She got water in her basement, so she sued me, I think, in 06. It could have been 07. Well, I filed a claim with my insurance company, and we went through, a long time of debating and stuff, and it finally was settled that they do not have to cover that under the liability section of my homeowners. And it's been forever since they've done anything. So my question is, how long can someone drag out a civil suit like that? Now, we did do all the depositions. We did all the discovery.
Right.
We did all the fact findings and whatever else is out there. So how long can they drag that out?
Well, if it's been sitting forever, basically, as long as both sides are, Jarndyce v. Jarndyce. But the question is here, why don't you go back to the court and say, I want my trial, okay? But you may not be in a rush for that. Or you can go to the court and say, hey, they haven't done anything in X number of years. I think you should dismiss this lawsuit for inactivity. But the danger of doing that is called sleeping dogs. Sometimes when you kick them, not only do they not run away, but they turn around and bite you. So, those are your...
One option is to ask the court to...
You file a motion and say, I'm ready for trial, Judge.
Yeah. And then the other...
The other side's got to answer it.
Yeah. And the other option sounds pretty similar, and that is to...
File a motion that says...
Just tell the court that says ask them to speed things up?
Well, in the second motion, you say to the court, I want the lawsuit against me dismissed for failure of the other side to prosecute it forward in a timely fashion.
Okay.
There used to be a case called pen piping years ago. When they used to say you got piped, there was a per se 2-year inactivity rule. And what happened, though, was it got to be a whole fight over what was significant docket activity or not, and the Supreme Court eventually withdrew the per se rule. But we still have a rule that allows for you to basically allege a non-prosecution of a case and get it dismissed. And it has to be over with the passage of time and prejudice. But so that would be the smarter of the two to file because you're the defendant, right? You file that rather than I'm ready for trial. If you lose it, then you say I'm ready for trial.
Okay. I think I am because I think it's a strong case. And, of course, we always think we have our own strong case. And, of course, the other party thinks that too. But it seems like a pretty easy decision. I don't know. But it was just a very eye-opening thing to me. I've never been sued in my life, and I never dreamed of being sued in my lifetime. But I want the listeners to know that someone does sue you. Be prepared to last about 10 years for a civil suit. I couldn't believe it.
I know. Got to let you go, brother. Hey, guys, we'll be back next week, 1 to 3, answering your legal questions. It'll be Easter weekend, so enjoy preparing for the holiday. It's time to do those little Easter egg hunts. Might get some trout fishing in today. Did some shooting with Steve Snyder in the office earlier. Take care, guys. See you next week. Pennsylvania has put in place a statute which controls what factors a court could consider when awarding custody or must consider. And that's found at 23 PACS 5328 of the Domestic Relations Code. Now, while these factors are Pennsylvania and statutory, the general precepts would apply to custody cases in most states. The court says, in ordering any form of custody, the court shall consider the best interest of the child by considering all relevant factors, giving weighted consideration to those factors which affect the safety of the child, including the following. which party is more likely to encourage and permit frequent and continuing contact between the child and another party? This one's probably the most interesting because it basically means if you're the person who's going to share the child more, then you're probably the person we should put the child with. I often encourage clients to consider not withholding custody unnecessarily simply because this factor will be used against them at trial. A judge may say, you have not been giving or permitting frequent and continuing contact with the other party. I don't trust you to facilitate the non-custodial parent's relationship, so I'm going to award custody to the other person. And that factor alone could carry the day if everything else were equal. The second factor is the present and past abuse committed by a party or member of the party's household, whether there's a continued risk of harm to the child or an abused party, and which party can better provide adequate physical safeguards and supervision of the child. So if you or the people in your household have a history of abuse, and if there's a continued risk of harm to the child, or who can provide better, adequate physical safeguards and supervision, those things will all come into play. Pretty much common sense here. If you live with a child abuser, you're going to have difficulty with custody. If you have a history of abuse, this is one of the reasons why people shouldn't simply just go in and be found to have committed acts of domestic violence on a PFA, for instance, and may want to fight those, because sometimes people will simply admit the allegation to avoid a hearing, but it'll later be used against them in a child custody proceeding. The third factor is the parental duties performed by each party on behalf of the child. That means, before people split up or even during a prolonged split up, who's doing what with the child? Are you the person who's providing the primary care? Are you going to games? Are you doing all the things that a parent does for a child in an intact relationship? And what was the division of labor? As we know, between some couples, even in intact families, only the mother or the father is basically providing time and attention to the children, whereas in some split homes, the duties are still split fairly equally. So this will vary on a case-by-case basis. But again, active participation, knowing your child's teachers and things like that, and spending time with the child and taking care of the child are the things that the court is supposed to look at. Number 4 is the need for stability and continuity in the child's education, family life, and community life. Words stability and continuity. Stability says which parent's going to provide better stability, and that can be important. The second word is a little different. Continuity means who's going to keep things the same or help keep things the same. So again, keeping the marital home might give you a strategic advantage in terms of family life and community life, whereas if you move a long distance away, that may make a break in continuity of the child's education, family life, etc. But then again, you may be the more stable parent. But generally in this context, it sort of is directing you towards thinking about not changing the child's life dramatically. So if you're going to make a move out of the marital residence or otherwise want to change the custody situation, it's best to stay in the same school district and around the same family members. On the other hand, perhaps a move out of state to a better school district to the location of the children's grandparents would also have arguable merit. Number 5, the availability of extended family, which is what I was just talking about. So again, moving to or providing extended family is considered a benefit. Number 6, the child-siblings relationships. Here we don't want to break kids up if they have strong sibling pairings. We don't want to take a child even away from a step brother or sister if there's a strong bond there, and that's a factor the courts have to consider. Number 7, this one's a biggie, the well-reasoned preference of the child based on the child's maturity and judgment. We're not going to let a 4-year-old pick where they live generally. But if a 16-year-old says, I find it easier to study at my mom's house and here's why, that's going to carry a lot of weight. There's no magic age in Pennsylvania, by the way, so it's just the child's maturity and judgment as weighed by the judge, and then the preference of the child. Quite often children have no preference, but they will tell both parents they have a preference simply because they're afraid to upset either of them. So keep that in mind. The best way to find the child's preference is through a counselor in our experience. Number 8, the attempts of a parent to turn the child against the other parent, except in cases of domestic violence where reasonable safety measures are necessary to protect the child from harm. This is the old parent alienation syndrome, where somebody works hard to make the child believe the other parent is bad or wrong. There seems to be an exception here for domestic violence. So what you say and how you conduct yourself vis-a-vis the other parent can be used against you. So speaking ill of the other parent is not a good idea, nor is it good for the child. Number 9, which party is more likely to maintain a loving, stable, consistent, nurturing relationship with a child adequate for the child's emotional needs? Quite frequently when we've had professional evaluations done by a custody evaluator, it'll turn out that one of the parents connects with the child on a much better nurturing or emotional level. Quite frequently, that's the parent you would think it is, the one who seems more nurturing and emotional, but not always. So somebody's gruff demeanor doesn't necessarily mean they can't fit the bill here. Number 10, which party is more likely to attend the daily physical, emotional, developmental, educational, and special needs of the child? So if you're an over-the-road truck driver and you're out of town 65 hours out of the week, including weekends, there's probably a good argument that the other parent will fit the bill better here. On the other hand, if you work from home and your spouse doesn't, you may make an argument that you'll better be able to do these things. But this also has to do with the overall parenting skills as we would traditionally see them. And so this is kind of a big area of controversy in any custody case. Number 11, the proximity of the residence of the parties. In the judges splitting up custody, the proximity of the residence is important. If one person lives in Utah and one person lives in Pennsylvania, the split can't be 50-50. On the other hand, if you live 1 mile away, all other things being equal, probably the split should be 50-50. So keep that in mind if you're planning to relocate out of the marital residence or move. The closer you stay, the better your chances of keeping custody. On the other hand, if you have a solid leg up on the other party, moving away could make a strategic advantage because the child would need to go with you and the physical proximity would not be helpful to the other side. But I'd be very careful about strategizing such a move, as courts tend to hold moves against parties if they believe they're being done merely to frustrate custody. Number 12, each party's availability to care for the child, ability to make appropriate child care arrangements. That goes back to who's at home, who can be at home when, and who can afford daycare and or has family members which would help with daycare. And while this is a little more mechanical than the prior ones, it basically does come down to who has access to the babysitters and who's going to do the best job taking care of the child care on a day-to-day basis. So a stay-at-home mom or dad obviously has a leg up here. 13, the level of conflict between the parties and willingness and ability of the parties to cooperate with one another. Parties' effort to protect a child from abuse by another party is not evidence of unwillingness or inability to cooperate with that party. This can be frustrating for courts because quite often the parents will fight over the child like a football and always looking to dive on somebody else's fumble. That said, the ability of the parties to get along well, and particularly if there's one person who can, that may not be enough because it takes two. And with high levels of conflict, frequent exchanges in custody don't make sense. So courts are going to be more likely to tailor the custody exchanges and the custody situation to work around the parent's problem, which is unfortunate. Number 14, the history of drug or alcohol abuse of a party or member of a party's household. History of drug or alcohol abuse, it is what it is. Obviously, people's histories in that area do come into play in the custody cases, although quite often observations made that the drinking or marijuana smoking or whatever else was going on was fine while the parties were together, and it's suddenly become an issue. It's going to vary from court to court how they handle it. Some courts have very little tolerance, for instance, for marijuana. Other courts have more tolerance for recreational use of marijuana in custody cases. And when it comes to alcohol, given its prevalence in our society, courts struggle with this as well. Number 15, the mental and physical condition of a party or member of a party's household. If you're living with somebody who's a stark raving lunatic, then we might not want to expose the child to that. On the other hand, if somebody in the family does have some mental or physical conditions which are detrimental but can be worked around, the court would consider that as well. Also, the physical condition of a party, for instance, in a grandparents' rights case, a grandparent may be perfectly fit for all their reasons except for their extreme age and their extreme lack of physicality because of their age. So those are things that courts should consider and do consider. And number 16, any other relevant factor. This is the catch-all. So if there's anything in your case that wasn't handled by these first 15 factors, this is it. The rest of the statute goes on to talk about some other things, but I think the most important point I would highlight is Pennsylvania says, gender neutral. In making a determination under subsection A, no party shall receive preference based upon gender in any award granted under this chapter. That's to make it clear that moms are not better than dads and dads are not better than moms. Each has equal standing under the law. This little quick overview of the custody statute was for your edification. I'd strongly recommend you study it online and in writing and try to work out what might fit under there in your various case and work with your lawyer on the same. Obviously, this little run-through isn't meant to substitute for sound legal advice. Do you have a legal question you want answered? Go to romingerlaw.com. That's ROMINGERLAW.com. romingerlaw.com to get your question answered.
WHP 580.
All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Welcome back. Carl Rominger here answering your legal questions, 540-0580. Leslie, I know you've been holding patiently. Let me get right to you. But I want to remind folks here, at 3:30, I'm going to be over in Lemoyne at the tobacco company smoking a cigar or three. So if you would like to stop over and smoke one with me, I would appreciate that. In fact, the way this came up last week, I mentioned my favorite cigar joints on the air. And I swear I said Lemoyne, but according to one of the owners over there, as I heard through the grapevine, I forgot to mention his shop. So I decided that I would get him back, so to speak, by piling it on. So I'm trying to get as many people as possible. What I really like to see happen is them run out of room and not have room to accommodate us. That's my plan. So if you're a cigar smoker, you know a cigar smoker, you want to try a cigar, and I'm not going to be responsible for any bad habits. So if you already have bad habits, come hang out with us. If you don't have any bad habits, just come and watch. 540-0580. Leslie. Okay, Leslie, let me recap for a second. You're talking about a divorce here, and you wanted to know if one person's income is higher than the others.
Social Security.
Okay.
They cut into the higher person's Social Security.
Well, I mean, theoretically, I guess you could have a redistribution of the Social Security income, although there's special rules with that, and it's hard to attach. But theoretically, yeah, if there's an alimony payment or the like, it might be based on the fact that one person's making more than the other.
Mm-hmm. Okay, another question. If you've been arrested and everything is just, you're out of your mind with all the stuff that happens when you're arrested, and later on someone says to you, this was maybe a month or two, later on someone said, where you read your rights, and the person that was arrested said, he said, I don't think so. I don't remember that I was.
Mm-hmm.
What,
Well, if you're not read your rights under the law, basically you can still arrest a person, you can still prosecute them. You don't have to read them their rights. The only remedy is if you get statements from that person at a time that they were in the functional equivalent of arrest, under arrest, or in what we call custodial detention, then those statements would not be admissible, and consent to search and things like that may taint any searches. So a Miranda warning is a prophylactic measure that the Supreme Court said should be given to remind a person of their right to remain silent and their right to have an attorney, but it's not a prerequisite to an arrest.
Mm-hmm.
All right?
Okay.
All right,
thank
thanks.
you very kindly. Have a good day over there.
Yeah.
Sounds like you're going to have a lot of fun.
We're going to go to that tobacco company and smoke a couple cigars. It does sound like fun. I'm hoping a few of the listeners will join us. And, of course, if they don't get there today for whatever reason, then just go and stop in there, and when they buy a cigar, tell them that I sent them. I really just want to prove to him that I have more than him listening to the show.
Well, you better watch, because you didn't ask me, so next week you're going to get... You're going to get yes the men and not the women.
Well, no, we let the women come too. In fact,
okay. Thank you.
In fact, I was just telling somebody I was guessing we probably have girls in sailors uniforms showing up, like a troop ship or something. 540-0580. Mike, you're on the air.
Hey, how you doing? My question is, I'm out car shopping for my daughter, and we're looking at a car lot that offers leasing on used vehicles, not a buy here, pay here, but a true lease, which is closed end, has a money factor, which happens to be 0. And my question is, what is the most they can charge her for document preparation? Is there a state limit?
Steve, do we know the answer to that? I don't know the answer to that.
I would say the answer is they can charge whatever they want, but they don't. But you don't have to pay that. I mean, that's a negotiable issue, and I have to believe that if you've agreed on a selling price for the car, and you're just concerned about the fee that they charge to prepare the documents, and you tell them that you think that's too high, and as part of the deal, you're not willing to agree to that, they should be willing to negotiate that with you. I don't know of a state law that limits any fees that are charged for administrative services. But again, I think you have the opportunity to either say, we'll take it or we won't take it. So I would just recommend that you say, look, I think that document fee's too high. If you still want to sell us this car, then you have to eliminate or reduce that fee.
What do you think? Where'd he go? I think we lost him. He must have jumped off. Abe, you're on with Carl and Steve. Abe.
Oh, there. Sorry, Carl. Thank you. How are you guys?
Good.
Good. Hey, I have a friend that has power of attorney over her mother who is an alcoholic. Now, she called me yesterday asking me if I knew anything or whatever, and I suggested that she call you guys. But her mother has a live-in boyfriend that they're saying they can't get rid of him, but when they go over there, there's no food in the fridge, the house is trashed, and basically they know that he's not taking proper care. And she has called the cops. They say there's really nothing that she can do, even though she has power of attorney. I don't know, is there anything that she can do to maybe take care of her mother or remove this gentleman from...
Is her mother competent?
Yes.
That's the problem. I mean, incompetent people can associate with bad people, so... competent people can associate with bad people and make poor choices if they want.
And that's what I was under. That's what I thought as well.
Yeah, and that's the problem. And you know what? It reminds me of a judge that told the story of a guy on the stand who the kids brought him into court, tried to declare him incompetent, and their main thrust was that he was spending down his $6 million fortune and had spent $2 million in 1 year with nothing to show for it. And the guy looked at the judge and said, I know exactly what I'm doing. My plan is to spend all my money so that these little rats don't get any of it. And the judge said, it's competent. It's not, it's maybe not nice and maybe not smart, but that's the way he wants to live his life. What am I going to do? He knows exactly what he's doing. And so that's the irony. That's the rub. And unfortunately, again, we've had this question before. We've had people that just are elderly or infirm for some reason, and they've had some assistance. But then they start to do things that the caregivers or the people that have been helping them don't think is in their best interest, but they're not quite incapacitated enough to usurp their authority. And, of course, none of us want to be usurped in our authority prematurely.
Right.
So
yeah, her biggest thing was her mom being an alcoholic and liver disease and all that other stuff that's going on, and not the proper care of her mother, even with a live-in. So she just didn't know if there was any recourse that she could take because it's driving her up the wall. And I think you pretty well answered the question.
All right, my friend. Take care.
Thanks, Carl. God bless.
540-058. We're going to go break here in a second, but I want to remind people, go to weekendappointment.com, get the free will kit. You fill it out, you send it in, and we give you a real live will. Lots of people do that. I get lots of those in. If you haven't done it and you don't have a will, there's no excuse. If you do have a will, I understand. But again, we'll do updates as well. So if you haven't redone your will in a number of years, and it's pretty funny because sometimes people come in and they hand me an old will to look at, and it'll be from 1984 or something like that. And obviously circumstances change, and so it's not a bad idea to, I say, about every 5 years update your will, if for nothing other than to have the lawyer make sure that the law is still the same as when it was written, and number two, to make sure that for estate planning purposes nothing's changed drastically that would make you want to reflect on it. And so doing that update is a good idea. 540-0580. Jerry.
Hey, Carl, how you doing?
Good. What's going on?
Well, I was listening to the gentleman who was calling about leasing a used car for his daughter, and I wanted to try and warn him off that. That's really generally not a good idea to lease a used car for a number of reasons. One, the usury laws do not apply. They can jack up his payments. His interest rate would be amazing. Number two, he's not going to own anything at the end of the lease period. Number three, oftentimes these cars are required to be maintained at the cost of the lessee, whichever, by the person taking the car, and they're oftentimes required to have the car maintained at the location where they're leasing it from. And a number of other problems with that. Leasing a new car may or may not be a good idea, I guess, depending on your financial situation. But leasing a used car is almost always a bad deal.
I think that's good advice.
All right. Well, I appreciate it. I'm sure that some people out there go, what's he saying?
Yeah, I know. Hey, and by the way, Larry Boyle is a good friend of mine. I know he's a good friend of yours, so I wanted to say hello to you from on that.
Well, I appreciate that, and Larry is a great guy, and taught me election law back in the day as well.
Yep.
So, all right, my friend.
Take care, my friend. Bye.
Thank you very much. And Larry's also a cigar smoker, so maybe he'll come down to Lemoyne at 3:30 and join me for my little smoke in. And if you're listening out there and you're a cigar smoker, I want you to get to Lemoyne. Let me get the address out here so you guys know it. It's something. I got it right up here on my Facebook page.
829.
What is it? 829.
Yep.
829. What street's it on? Hummel.
State Street.
State Street. 829 State Street in Lemoyne. Okay, that's where I'm going to be at 3:30. Let's see. We got to go to break here, huh, Shane? Shane's pounding on the window, which means we're going to break. I think we're going to break. Shane, are we going to break? Shane, are we going to break? Are we going to break? You better hit the button, buddy. Well, welcome back. 540-0580. Carl Ramacher. I got Steve Snyder floating around answering your legal questions as well. And we'll go through We'll go. Hey, Steve. Anything you want to tell people real quick? Anything you want to pitch or anything we should know about? Or
no, I think we've done enough pitching on this show today, Carl.
What? We're just pitching the tobacco shop in Lemoyne.
Sure.
Melody, you're on the air. Hi, Melody.
Hi, Carl. Thank you for letting me pick your brain. I got a landlord-tenant question, have a judgment against a tenant, and understand that she's getting a refund from the IRS. Can I garnish it?
Well, the short answer is I don't think there's any way for you to intercept those two if I had to guess.
But what about for next year, when she files next year?
No, I mean, that's what I mean. I don't think you can get in between those two. Not that I'm aware of anyhow. And in Pennsylvania, you can garnish wages. So if she's getting a refund from the IRS, she's inevitably probably getting some wages, right?
Yeah.
So that's your best route. So what we would do is simply execute a garnishment against her wages.
I don't know who she works for.
Well, that's not too hard to figure out if we did a little research. And we might not even need to know who she works for so much as once we start the garnishment process against her, we may be able to force a disclosure with what we call interrogatories in support of collection.
Okay, she does have a very nice car.
Yeah. Well, Melody, how much money do you show you?
$2,800.
All right. Well, my advice is I would consider seeing a lawyer and working out. A lot of times when we do collections, and I say we, I mean just lawyers in general. I mean we do them, but just lawyers in general usually do it the kind of same way, which is you want to pay me hourly, or you sometimes can pay me a percentage of what we collect. The standard percentage in the collection history is usually 50% for lawyers.
Uh-huh. So in order to get her car back, I've got to go through an attorney?
I didn't say you have to. But I'm saying you got to go fill out all the right paperwork and get things done, and that sometimes is where the attorney comes in handy.
Yeah, I understand.
And sometimes we don't even have to go that far. Sometimes we just write them a letter and they send the money.
Yeah, I don't think she has the money to send, but if I sold her car, I'd be able to get the money from
right,
it.
Or garnish your wages. I mean, that's the whole point of the garnishment process.
Yeah, okay.
All right.
All right, thank you
all
so
right.
much.
You take care.
All right.
540-0580, Carl and Steve answering your legal questions here. Bob, what's going on?
Hey, Carl, this is Bob. How are you?
Good.
I'm looking forward to coming down and having a cigar with you. That's a great thing. And I think last week, though, I listened to your show last week, and you did mention the tobacco company on the air.
See, I thought I did.
You did. My wife and I were just talking a little while ago, and I said, no, he did mention because that's where I like to go.
Yeah,
and then you actually mentioned Dave, too, so.
Yeah, so you know what? He's really whiny, isn't he?
Yeah. No, he's a great guy. I love those guys down there. I was just saying you got bamboozled if they said you didn't mention.
Yeah, see, now I'm really mad. All right, well, then we're going to go down there, and we're gonna really give it to him.
Yeah, but I have a follow-up. You had a guy on right before the 2 o'clock that had a hospital bill that wasn't paid because his benefits weren't signed up in time?
Yeah.
Yeah. Well, if he's on an employer-sponsored plan, his recourse is to go back to the employer because they have the responsibility of providing that information to the insurance carrier. So he might have recourse against the employer.
He may have recourse.
Yeah, if they didn't send in the benefit form, the enrollment form, for him to be added on.
Right.
And on the general liability policy, too, there's a coverage that he has recourse again. It's called the employee benefit liability. That covers that type of error for the employer, for the administration. If they do something like a screw-up like that, that's where they can go for coverage if they have that coverage on their general liability policy.
Right.
So I just wanted to share that with you if he's still listening to check in and see if his employer dropped the ball on that.
I appreciate that.
You bet. I'm looking forward to meeting today at 3:30 down at the tobacco company.
Yep, I'll be there in Lemoyne.
All right, thanks, Carl.
Thanks. You heard it, people. People are actually going, so we'll see how many people we can get in there. I want to cram the place. Mike, you're on WHP 580 with Carl Rominger. What's going on?
Hey, Carl. Hello.
Yeah, I'm here.
Carl, yeah, this is Mike. I had called a little earlier, and I somehow lost you. The second part of my question was on the leases, used car lease. Is the origination fee? I take it that's the same thing. There's no set state fee or whatever.
Right. There's no minimums that any of us were aware of.
Okay. And my compliments to the gentleman that called in and said, "Hey, leases, you got to be really wary," which I was. I'm pretty affluent with different things as far as rental agreements, stuff like that. But this is a closed-end lease. It is a 0% money factor where there's no interest, and you can walk away from the lease and not have it affect your credit as long as, you could turn the car in the pretty much the condition it was in. And that's why it looked attractive versus something like a buy here, pay here, where if you don't make the payments, of course I'd make them for her, but let's say you didn't make the payments, then it affects your credit, where in this leasing situation, you can simply, if you have hard times, turn the vehicle in and walk away from it. And so it looked pretty good. I mean, I guess it's curtailed to how this particular dealer does his versus other dealers, but like I say, with the knowledge I know about different things, if you've got a 0% money factor and no interest, and it's closed end where your residual, once you meet your lease term, you can buy the vehicle at a set price, meaning closed end, and the walk away, I mean, I think it's a good way for her to buy it and start to establish some credit.
Yeah. Interesting. Well, I mean, it sounds like you know what you're talking about. The other thing I remember about how to buy a car is my usual technique is just kind of like what Steve was saying. What origination fees? What are you talking about? I thought it was $6,000 for that vehicle. But here's my check right here. I wrote it out. What am I going to do? I guess I have to leave now.
as he had explained it to me, there was an origination fee and a doc fee, which the doc fee is $99, and I think the origination fee is $550. But then there's no, you're paying 0%. They've got to make something on their money.
Right, and that's probably where they're making it.
Getting, which is a lot less. I would imagine if you computed it out, it comes out to about 4%, 5%. I don't remember what number I computed it out to over the course of the term.
Mm-hmm.
So it seemed pretty good. I mean, who's going to put their own money out there and let you take a vehicle and not make a dime? I don't think they'd be in business that long. And the guy's been around, a long time. I bought in retail from him on some new stuff, but I had never bought a used car via leasing and that. And it just seemed to be a way to build her credit, because if you go to a bank, they want 9%, I guess, on a used car.
Mm-hmm.
They're pretty high on a used car, so I didn't really look into it. So, anyways, that was my question.
All right. I appreciate it, and I'm glad we kind of hashed out a lot of interesting things here today.
Sounds good.
All right, my friend.
Thank you. I'll try and be over in Lemoyne. I'm not sure if I'm going to be able to or not, but if I can, I'll stop over and have a cigar.
Yeah, please do if you can. I mean,
great.
I mean, hey, it's not that big of a commitment. Just smoke a little one.
Yeah, exactly. So, all right.
All right.
Thanks.
Okay, who's next? Joan, you're on the air.
Hello.
Hello.
Thank you for taking my call. My question involves inheritance tax.
Yes.
Now, one of my parents passed away years ago and transferred the home for the 3 siblings, and the one sibling has passed away. So we have to pay inheritance tax on the first one, but do you still have to pay it on the second one where they pass away?
Well, I don't know. I'd have to see how the property was left to the siblings. If everybody got equal shares and then that sibling's share is somehow going back to you guys, it may be possible that there's an inheritance tax on it, but it all depends on how it was deeded and transferred.
Well, it was transferred by my mother years ago for $1 that she left it to us years ago before she passed away.
Right. And I would have to take a look at it. I mean, what I'm saying by that is you're saying if she passed away and you guys all took a third of it?
Well, if the one sibling passes away, you have to pay inheritance tax a third for the first sibling. You still have to pay it for the second sibling when that sibling dies, and then finally when the third one, and that goes to the estate, do they still have to pay again?
Well, the short, I guess I'm not following is...
Would that be, how many times can a property be...
It can be taxed an infinite number of times if it's transferred an infinite number of times in taxable transactions. But we'd have to see how it was structured and whether or not it's going to pass for tax purposes or not in a taxable way.
I see. Then I have another question, if you don't mind.
Yeah.
If you have EE bonds, and you're the owner, and you have the co-owner, and the co-owner passes away, do you still have to pay inheritance tax?
Well, theoretically, you might, but it depends again on who the co-owner was. So, for instance, if the co-owner in the jointly owned property was a husband or wife, the answer is no.
No, this is sisters.
Yeah, sisters. Then it's going to be there's going to potentially be an estate taxable event.
So, although the second co-owner never contributed or bought the bond, you still
their name's on them.
Oh,
yeah, that's the issue. We've had this come up where people go and they put money in a bank account with their mother, and then their mother passes away, and they go, how come I'm getting taxed on the money in the joint banking account with mom? And the answer is you're going to get taxed on 50% of it. Or if it's been less than a year, you're going to get taxed on 100% of it, if I remember right.
So in other words, you'd be taxed on your own money.
You can, right, and that's why people have to be careful when they commingle funds with others, that they may create a taxable event that wouldn't have been otherwise.
But then that does prevent you from going to probate, though.
Right.
You have all the joint ownership.
Right. Well, that's right. Keeps it out of probate, but at the same time, there may still be an inheritance tax due.
Okay. Well, thank you so much.
All right, Joan. My recommendation for anyone who's thinking along Joan's lines is to sit down with a lawyer and go over all these things and kind of plan them and map them out because there may be ways to avoid it. I was talking to another lawyer the other day who's writing a will for a same-sex couple. And that gets to be a problem because the tax rates are between private individuals. They're not treated as family members. So there's sometimes a lot of structuring and things that you like to do in those cases that you might not with a married couple, but then you don't have all the benefits of a marriage either. 540-0580. We'll get back from break. I think Robert Culling's going to join us. Steve Snyder's still here, and we'll talk with Lee and Joe.
I'm going to drop off, Carl, because I got to get up to the tobacco company.
All right, I'll see you there.
Okay, bye.
And those are very good cigars, and those are made locally, so those are interesting. But yeah,
where can I get a good Honduran smoke, good Honduran blend in this area? I'm still fairly new.
You know what? Well, if you're in the area, you could go to the Tinderbox down in Lemoyne.
Oh, okay.
That's a really good cigar shop. Dave that runs. They have one of probably the largest selection in central Pennsylvania. If you're looking for a really nice, fun place to smoke a cigar, there's 2 in downtown Harrisburg.
Right.
Ray's Tobacco and the other one right on the corner on 2nd Street. And the name's escaping me for a second, but those guys are really nice too. And that's a fun place to just go in and hang out.
All right, well, thanks a lot, Carl.
All right, there you go. There's the history of last week, and I figured out what it is. I did mention Lemoyne, but I said the tinderbox, and I meant the tobacco company. So now it's all been straightened out. But as a result of all the controversy that stirred up last week, I am now going to the tobacco shop in Lemoyne today to smoke a cigar at 3:30, so I'm hoping some of you guys will join me. Rob Culling, what are you up to?
Not too much, Carl. How about you?
Well, what do you think I'm doing? I'm on a radio show, Rob, obviously. What are you doing? I mean, come on now. Nothing? Nothing at all? You got nothing cases you're working on or anything?
Well, actually, I'm gearing up for a couple custody trials at the beginning of the next month. So, yeah, actually getting my writing skills down, getting my witnesses prepared. So I'm getting ready.
Good. And those, people don't realize that, but a custody case can turn into a full-blown trial. There's no jury, but other than that, they're not much different than a big civil suit or a big criminal case.
Yep.
All right, Rob, hang around and see what we can answer some questions for people here. Joe, you're on the air. Joe.
Oh, hey, that's me. I have a couple questions regarding a union situation at my place of employment. First, to start it off, I'm wondering if there's any stipulations for what constitutes fair share. A case in point where we work, we got a 2-week pay period. Say somebody's scheduled, part-time employee scheduled for 4 hours in that pay period. They're paying the same amount as somebody that's working 80 hours in that pay period. Is there any stipulations for what constitutes fair share?
I do not know. Now, labor law is a little outside my expertise.
Gotcha.
And more importantly, if you have a labor contract, a lot of times that's going to control. So the individual contract a lot of times says as much.
Okay. Employees have been complaining about this for a number of years, and evidently a new contract was drawn up that's supposed to address the situation. But now we've discovered that people paying the fair share are going to continue paying the higher rate, and union members are going to get a discounted rate. So we're being coerced to join the union, basically.
Yeah, that doesn't seem quite right.
No.
That doesn't seem quite right.
Yeah, there's a lot of other things going on. But I understand this is out of your purview. So is there anybody you could recommend me to, a labor lawyer or a state or federal agency?
Well, yeah, I mean, technically, the National Labor Relations Board, right? Although they're not always, particularly when there's a Democrat in the White House, particularly friendly to the anti-union forces, if that makes sense.
Yeah.
Other than that, in terms of a labor lawyer, not sure. If you want to just contact us off the air, I'd be happy to try to find you one.
Great. Okay, through your email?
Carl, Karl, at Rominger, ROMINGER.com, or you can just look me up on RomingerLaw.com or weekendappointment.com.
Great. Okay, sounds good. Thanks, man.
All right, no problem. Bill, you're on with Carl and Rob. Bill.
Hey, Bill, Carl, you guru. I heard on the radio just in passing somebody said that something like going to the courthouse because of the Homestead Act, and if you register or something under the Homestead Act, then if the creditors ever came after you, they couldn't get your real estate or property. I'll just jump off when you get through answering that. That's all I know about that.
All right, my friend. Here's the answer. I don't know of such a thing. I know in Florida they have a Homestead Act. And so, your property can be your homestead, and that's why a lot of rich people choose to put their primary residence in Florida, because it's shielded in a way that property isn't in other states. And so, for instance, if somebody dies in Florida and they use a homestead exemption, they don't have to pay. The estate doesn't have to pay any debts out of the value of the home, for instance. So Florida would be the only place I know of that being effective in, and I don't even understand all of it because it doesn't become an issue up here in Pennsylvania that I've ever encountered or I'm aware of. So that's the best answer I got. 540-0580. Call in. We'll answer your legal questions here on the air. 540-0580. Carl Rominger here answering them. And, of course, if you need a lawyer throughout the week, just go to RomingerLaw.com and you can find us. I've got Rob Culling here. Of course, earlier we had Vinny and Steve. So I'm trying to help you guys get to know all the lawyers in the office because they're all good guys and we can all help you. Lee, you're on the air.
Hi, Carl. How are you doing?
Good.
I like your show.
Well, thank you very much.
Always interesting. I have a question about something that happened to my grandson.
Okay.
He just rented an apartment in an apartment complex, and he ran into two snags. The first one was the cable company refused to hook him up because the prior tenant did not pay his bill. And the second one was the electric company wanted to charge him an exorbitant down monies, and they said it's because the prior tenant did not pay his bill. What's any recourse on those?
Let's see. Now, that's interesting. So the power company is going to hold
$300, which is more than they would normally, and they told him that's why.
Right, and they're going to hold it against him that the last tenant was a credit risk, apparently.
Right, and it's an apartment complex too. It's not an individual with townhouses or something.
Right, that's very interesting. I guess they could do that. I don't know. The PUC would be the people to talk to about that one.
Okay.
Public Utilities Commission could tell you if that's kosher or not. The other issue is what they're trying to do on the other one.
The cable company won't hook him up because the prior tenant did not pay his bill, so it's on a do not serve.
That I would appeal as well to them, but I'm not sure because cable's kind of a monopoly. There's got to be some regulation of that as well. So again, that might be a PUC question as well, since it's a regulated utility. But I don't know who actually runs the cable folks.
Yeah, and I don't know which cable company it is either. So
yeah, but it sounds like he's getting hosed for something he didn't have anything to do with. Maybe he needs a new apartment.
No, he just got this one. But as soon as he mentioned that he was regular Army with the electric company because they were trying to arrange a time for him to go meet somebody and he can't, they dropped it.
Ah, okay, interesting.
Yeah, I thought that was interesting too, but it just seems to me that it's not right and shouldn't be.
Now, we increasingly in our society, because of our ability to database and index, we're starting to hold things. We're actually going back a few thousand years, and we're starting to hold things against people. We always did, but also now back again against objects and places. And what I mean by that was back in the old days, like in Rome, if somebody got killed, they might not only banish the person, but the instrumentality of the crime would be thrown into the sea and banished because there was a theory that there was some taint or punishment that needed to be done to the inanimate object. Well, these days, the police database and the government databases, all the incidences that happen in a car or in a house or a location or with a piece of property, VIN numbers, tag numbers, individuals who are present. And so we're seeing increasingly, like the police pulled over, I'm aware of a case, for example, where my client was very upset because the police pulled over a car she was driving, started to hassle her, and she felt very belligerent. Well, what we found out was somebody else had been picked up in the same car a few months before with a handgun.
Oh.
And so even though it was a different driver, and a passenger had been extracted somehow and gotten in trouble and had a firearm, when the officer ran this particular license plate, the computer flagged it for him that there had been a illegal gun in this vehicle previously. And not to say that I don't think the officer should be entitled to know that, but it colored the entire encounter. And it's interesting because in the old days, the officer would have known anything about the person in the car, and it would have been just a friendly speeding ticket instead of the officer coming up guns drawn. And so... And the poor other girl had no idea that this had happened because another family member had used the car and neglected to tell anybody about the incident with their boyfriend and blah, 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 blah. And so my point is we're now now companies are doing the same thing. If you have insurance companies take every location, they've been doing this for years, and keep a claims history on it. So even if you move into a new building or apartment, the insurance company will have a feeling about it. And now you're saying the power company is doing the same thing and the cable company is doing the same thing. So we're no longer just making business decisions and extending credit or risk on the people, but also saying there's something inherent about this location that we're going to keep track of. And I guess the cable company's argument would be, hey, we've noticed that if we have an apartment where somebody doesn't pay one time, magically, more likely than not, that's the same one where they're not going to pay again, and there's some correlation between the cost of the rent and how selective the landlord is or the section of town or whatever it is. But statistically, it bears out that the location has some significance, so we want to make a business decision based on it.
I ran into the same problem when I moved where I am now and got a new phone number. I had the satellite people didn't want to deal with me because the phone number belonged to somebody who apparently didn't pay their bill. But we got that straightened out.
Yeah, isn't that interesting?
It's amazing. Too much information, maybe.
Well, yeah, that's kind of what I'm worried about.
Yeah.
Well, thank you very much. Good luck with that.
Thanks, Carl.
All right, you take care.
Have a good day.
Bye.
Bye.
I think at least sounds familiar to me. 540-0580. When we get back from the break, we'll talk to a few more people. And don't forget, about 3:30, I will be in Lemoyne at the Tobacco Company at State Street smoking cigars, and I'd like as many of you as possible to join me. Well, welcome back. Carl Rominger here. I'm just reading an article on myself. Chicken nuggets, how bad are they? Some kid, a 17-year-old British factory worker, was rushed to the hospital when she collapsed, struggling to breathe. During the exam, doctors were stunned to learn that Miss Irvin had never in her life eaten fruit or vegetables. Instead, she had eaten almost nothing but fast food chicken nuggets since she was 2 years old. Well, 15 years of nuggets, and I don't know if that's related to her collapsing or not, but can't be good for you. Cannot be good for you. Jim, you're on with Carl and Rob.
Hello?
Jim, yeah.
Okay, this is, my name is Jim, and my brother and I inherited a property from our parents. And I wondered what would happen if either one of us passed away.
Well, it depends on how the deed went. Theoretically, and I say this theoretically, a lot of times people go, well, you know, my dad left me the property with my brother. I'm like, well, would you go to the courthouse? Did a lawyer get involved? They're like, no. We just sort of took it over and paid the taxes in Dad's name. I'm assuming that it got deeded to you guys somehow.
It's both our names are on the deed.
Right, and you're probably either tenants in common or tenants with right of survivorship. If you're tenants in common, then you or your brother's estate would continue to own their 1/2 interest. If you're tenants with joint right of survivorship, whoever dies, the other guy takes the whole thing.
Well, I think it's the former here. If my brother did pass away, could his estate force a sale?
Well, if it's tenants in common, then absolutely.
They could. Okay.
Absolutely.
Okay.
All right, my friend.
Thank you.
Of course, I'd want to actually see that deed just to be 100% sure. Robert, you're on with Robert and Carl.
Hey, Robert.
Hey,
Carl. This is Robert. I've got a question about a pension that could possibly be due me from an employer. I retired recently after 23 years with the company, very large international company. And one of my options was to take my pension as lump sum, which I did and have invested it myself. However, I also triggered Social Security, which I'll start collecting. And I received a notice from the Social Security Administration that there may be a period of time when I worked that I am also owed a rather small monthly amount from the year 1993. And I did work for the company then. I did have some broken service with the company and then returned to the company, and they grandfathered all my time and ended up with 23 years. They handle their pension through a third party, or a second party, actually, Vanguard, and they have provided me with very detailed calculations as to how my lump sum was calculated. Interestingly, the only year that is not taken into consideration in the calculation is 1993. And I'm wondering if what my next move should be to try to determine whether indeed I have this kind of little donut hole period of pension that apparently was not calculated when my lump sum was calculated a few years ago when I left.
And I don't know the answer to that.
Okay. And I've obviously tried to talk with my company, and they're quite nice, but they're going very slowly, and I suspect that the last thing they want to do is pay me a couple of $100 a month for the rest of my life when I've already requested lump sum. Right.
And I'd be interested in seeing what the we get the pension manuals and see what the understandings were.
Okay.
And what the rights and what you vested in, et cetera, et cetera. But it's basically like a contract at the end of the day. So you either are entitled to it or you aren't. And if you get a clear answer, then you know.
Okay. Well, I'll just continue to pursue it with them and possibly Vanguard.
Yeah.
Okay.
All right, my friend.
Thank you.
It's the best answer I can give you off the top of my head. Let's see here. Joel, you're on the air.
Hello.
Yeah, Joel.
Carl, quick question. I own a property up in north central Pennsylvania. I received a postcard from the power company saying that they were going to do some tree trimming. If you have any problems or questions, call this toll-free number. I called it twice, left my name message, no response. I called a district manager, forestry manager, left a message, no response. I go to my property, and there's 4 unnecessary trees cut down. What can I do?
Well, you may have a claim against them. All depends on the right-of-way understanding. So you're going to want to get a copy of their right-of-way and what the agreements are in there.
Well, I understand that, but some of these trees were, 20, 25 feet away from a power line.
Right. Well, that's what I mean, and I don't know what the agreement in that right-of-way agreement is.
How do I find that out?
That's going to be recorded. So somewhere at the courthouse, you're going to be able to find the power company's right-of-way across your property, and the terms and conditions that were either agreed to or gotten by eminent domain.
Okay, I understand this job that needs to be done if it's necessary, but some of these trees were completely solid, and they didn't look like they were diseased to me at all.
Right, and they may have got an overzealous cutter, so.
Exactly, that's what I'm thinking. Okay, well, I thank you for your help. Thanks for taking my call.
All right, my friend.
Have a good weekend.
All right, good luck. 540-058, Carl Rominger here answering your legal questions. Of course, I'll be back next week from 1 to 3. I'm going to be in Lemoyne at the Tobacco Company from about 3:30 to 4:30 today smoking a cigar. So if you're listening, I would love for you to join me. Oh, there, Chad, I'm going to have to get you next week, my friend. Rob, thanks. Talk to you later. Hey, guys, Tobacco Company here in about half an hour, just enough time to drink a soda and get over there and start smoking a cigar. And if you need to find me throughout the week, go to RomingerLaw.com. But again, come smoke a cigar with me in the next few minutes. I'll see you guys in Lemoyne. It's over on State Street. If you need help finding it, just Google it or look it up on your iPad. Do you have a legal question you want answered? Go to RomingerLaw.com. That's RomingerLaw.com. RomingerLaw.com to get your question answered.
Advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon. Carl Rominger here, 540-0580. Still a little snarl out there coming over here today. Took a little longer than normal. I have to keep diverting around the south side of the city and coming up the 83 way. So, but we're still on at the Harrisburg Beer and Cigar today at 4 o'clock for our cigar and gun chat. Come on over. We're going to be in the lounge. We're going to smoke cigars. We're going to talk about guns, gun rights, gun laws, and anything else you guys want to talk about legal related. And that's at Harrisburg Beer and Cigar, which is over on 3842 Union Deposit Road. It's over by the Lowe's in the plaza over there, across from, the Texas Roadhouse. So come on over. They've got great beer, great cigars. Really neat walk-in humidor. It's not a little thing at all, so I think you'd be really impressed. Now, it's a bring-your-own cigar event, which means you buy your own cigars. So when you get over there, you buy a couple cigars if you want to smoke one. With us and talk about the gun law. Of course, you don't have to smoke, but you will be in a smoke-filled environment, so don't bring your 8-year-old. Somebody asked, and I'm like, what? What else do I want to let people know? CDL Labor Logistics out of Carlisle seeking experienced, qualified commercial drivers with clean records. Call them at 866-293-1880. And I'm going to they're going to sponsor the show, so I was going to put an ad together for them, but apparently they need the driver so badly right now, they wanted me to just go ahead and do some live reads, so that's why I'm annoying you with it. So these guys, CDL Labor Logistics in Carlisle, 866-293-1880. Of course, if you call in, we can give you the number as well. But if you're a commercial driver out there and you've got a clean record, you're looking for a good, high-paying job, they've got them. And, of course, May 18th, we'll be at the Lancaster County Women's Expo. And earlier this week, I spoke at the Chambersburg 912 Patriots. I want to thank them for hosting me and giving me their time. They were very nice people. They were attentive, had a lot of great questions. And, again, if you have a group or an organization that meets – and you're looking to have somebody come in and talk about some aspect of law, we're happy to do it. 540-0580. And Will, you're on the air.
Yes, this is Will.
Yep.
Somebody's been getting into my father's house, and I have a game camera, like you shoot the deer and stuff. Can I record? It has a recorder with the video. Is that legal in PA to record sound inside the house?
Well, you can't record sound where people have a reasonable expectation of privacy.
Like if it's in the living room, not like a bathroom or something?
Right. And I would think, for all intensive purposes, an intruder would not have a reasonable expectation of privacy in your house.
Okay.
All right.
Thank you very much.
All right. Good luck.
Have a good weekend.
Go get them. 540-0580. Yeah, in Pennsylvania, we have these weird rules on recording things. And notice how he said about sound, because you can record video under Pennsylvania's Wiretap Act without any problem as long as it doesn't pick up the sound. On the other hand, you can record anybody on video you want in a public area because there's no expectation of privacy, and even pick up their sound communications without any problem. So keep that in mind as well. and we get this a lot in custody cases or other types of cases, but a lot of times in divorce and custody. Well, I have a tape that proves, and that's when my red flag goes up, because not only is it a felony to make the tape, but it's a felony to play the tape. And I can't counsel you to destroy evidence, so I stop the client right away and say, now listen, if you had a tape and you'd made a tape, I couldn't counsel you to destroy the tape because I would be counseling you to destroy the fruits of a crime. So we can't go there. And I know you weren't about to tell me that you recorded anybody secretly or without their consent, because if you did that, then that would lead to that other conversation that we couldn't have. So let's just move on. And some clients go, but no, I have a really good tape, and it shows blah, 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 blah. And I go, oh. And then I go, any chance it's got an answering machine? And they say, well, yeah, it's from an answering machine. Okay, well, if it's from an answering machine, there's, again, no expectation of privacy there. That's a little different. The person has voluntarily recorded their voice. The problem is when people don't know they're being recorded and it's involuntary under Pennsylvania law, that is not a good idea. Oh, what else do we know? Well, we talked about this. I don't know if we talked about this last week or not, but the Pennsylvania Supreme Court Justice is going to have to send out Jane Orey, disgraced for using her sister's senatorial office and her sister who worked for her in the Superior Court as campaign staff and using the staff to run her campaign, has to write a personal apology to every judge in Pennsylvania. But not just on a piece of paper, on a photograph of herself that she has to have made at her own expense and mail out to every judge in Pennsylvania at her own expense. I guess it would be probably like 1,000 folks or so will be getting that. And I was joking on the Durgan show yesterday. It'd be interesting to see if any of those will become available on eBay for resale and what those would go for. Kind of an odd sentence. I mean, she got house arrest and probation and some other things. She has to work in a soup kitchen, and then she can only leave the house to also go to church. So the judge made it not the posh form of house arrest, but the much more, much less fun version. Talk line number, by the way, is 540-0580. We got some openings on the board right now, so if you want to get in here and you have a legal question, it doesn't matter what it's about. If it's about child custody, got a neighbor's tree problem, get a lot of those. You had a bad car accident, and it seems to be all the rage right now since the entire conduit around this town is shut down. Oh, let's talk about this, by the way. On your way to a merge point, you don't have to. When it says right lane closed 2 miles ahead, okay? Think about this. Right lane closed 2 miles ahead. Who knows how long a mile is? It's really long, okay? Even at 60 miles an hour, it will take you, pop quiz, how many minutes to cover 2 miles? 2 minutes, you're right. So, point being, you come up on that and you see it. So everybody starts cramming into the right lane and creates this giant traffic jam. Take both lanes to the merge point and weave in at the merge point. You will make traffic faster for everybody. So keep that in the back of your head. A lot of people don't seem to understand that. Charlie, you're on the air. Hey, Charlie.
Hey, Carl, how are you?
Good.
I have a question and a comment, and it's the question is just a yes or no question. A friend and I were drinking a couple of Yingling lagers.
Okay.
And he brought up the castle doctrine of this Commonwealth, and he claims that hypothetically in the evening he's asleep, the afternoon, the night, whatever, and he hears a rattling in his living room, and he gets up and he goes out into his living room, and somebody's there in his living room. To quote him, he says, "That person's made a fatal mistake." And I said, I don't think it's that cut and dry. And then I'll give you my comment, and then you can answer my question. In terms of these accidents around here, I'm not going to tell you who I drive for locally. Well, I guess I will. I drive for UPS. And as a professional driver, there's no excuse for any of this, none. I don't want to hear anybody say that people are distracted. You as a professional driver, it doesn't matter what Joe Public's doing, you have a responsibility to maintain a high lead time, maintain a constant state of situational awareness. Mm-hmm. I just read the article this morning, and you can read it for yourself in the Sentinel, that I'm paraphrasing, I'm not quoting, the driver was not able to stop in time. That is so weak. I'm driving my equipment with my high lead time, like where I'm driving that truck, no less than a half mile ahead. Obviously, corners and hills change that variable, but I have a significant following distance. I'm reducing my speed. It's pathetically sad and weak. Like the tanker driver that rolled his truck on that 322 West. Seriously? I get it that we don't get IQ tests to maintain these licenses, but seriously, That is so weak. Think about it. If nobody, even Joe Public, doesn't agree with what I'm saying, this should make sense to anybody. You're pulling around upwards of 5,000 gallons of fuel.
Right.
Wouldn't you be reducing your speed? Wouldn't you be the vehicle out there that's annoying everybody? What is this guy's problem? And then this guy with 5,000 gallons of fuel goes into that curve, and then he's going to say something weak like he was startled, he was distracted, he had to swerve to avoid something. No, shut your mouth when you're talking to me. Shut your mouth when you're talking to me. No, you didn't. You're weak, you're pathetic, and you've got the whole East Coast, Central PA all screwed up now because of you. But that's my comment, and then you can answer my...
I can see you have a strong opinion on this. The answer is, and I want you to think about this. We get this one with the crack dealers too, right? We go. Why on earth would you be driving down the road with a kilo of cocaine in your car with a headlight out, going 85 miles an hour on the interstate, wondering why the cops have pulled you over and there's a drug sniffing dog out there? Wouldn't you have a chase car? You got $100,000 worth of drugs. Wouldn't you have a chase car and a car in front? Looking around and making sure all your stuff's working. Wouldn't you do an equipment check every hour or so?
Right.
But for some reason, human nature being what it is, crack dealers and drivers included, not everybody does all the things they could or should do.
Right. I don't know. Listen, I'm not on a podium for myself, but it's a statement of fact, not fabricated fiction, what have you, metaphorically. I've been doing this for almost 20 years, and I can tell you with 100% certainty, I've never had a oh my gosh, that could have been bad situation because I'm on point.
Right. Well, that's your job, right? And so here's the thing. We expect my mechanic to get the job. So I always get a little miffed when I hear people talk about the trucks. They always complain about the trucks, and I always want to be like, listen, the average CDL driver is a lot better driver than the average regular driver. So I would stop worrying about the trucks and start worrying about the teenagers and the 87-year-old blind guy.
Right.
All right, my friend, I got to go to break.
All right. Hey, can you answer the gun question when you come back?
Yes, I will.
All right. Thanks, Charles.
All right. Well, let's go back to that gun question for a quick second. Yes, you don't have to retreat inside your own house, but you can't just shoot somebody because they're in there. We don't have our castle doctrine as it's been adopted in Pennsylvania is not you can just shoot. You still have to have a reasonable fear for your life. However, we've said that the fact that a person is intruding gives a presumption that is the case. But a presumption is not a end-all. It could be rebutted. And so, yeah, a prosecutor could say, well, we start from the proposition that when you wake up in the middle of the night and somebody's scratching around in your living room, you have the presumption of the right to use deadly force. But under these circumstances, I can show you why that's not the case. Because as the guy was coming down the stairs, the person said, hey, what's going on? And the lights went on, and it was a 12-year-old, or some such thing where some fact came to light, making the person look or showing that the person was no danger, or it turned out to be the, what do I want to say, the autistic neighbor next door, 12-year-old who wandered in the house in the middle of the night, or something that you should have known or could have known under the circumstances. And when the guy says, well, yeah, I heard the scratching down there, and I ran around the corner with my gun, and I pulled it up, and I started pulling the trigger, and I was like, oh, look, that's Johnny the neighbor boy. When did you know it was Johnny the neighbor boy and know he was harmless? And that's the problem. That presumption could be rebutted. So I think the answer is don't use lethal force unless you have to. That's usually our argument, by the way. 540-0580, Carl Rominger here, coming to you live on WHP 580. Tom, you're on the air.
Carl, thank you for taking my phone call. I got two questions for you. One is the child endangerment, and the other one is final restraining orders. The first one, child endangerment, this is the situation.
Okay.
And this is a real good one, too. I noticed that on my neighborhood that one of the neighbors set up a basketball court on the street. The neighbor across the street said, boy, that's a really good idea. I'm going to set up my basketball court on a public street. Now, my question is, what are the implications of the law by creating an environment on the street, such as a playground, and does it fall under child endangerment?
Good question.
You got to remember that a parent authorized a playing instrument to be on a public street. creating a
Well, I got to ask this question.
creating a playground environment on a public street, which is child endangerment, reckless endangerment.
It's a community standard, and I'll explain it this way. When I was a kid, it seemed to me, I grew up in the country, but before I moved to the country, I lived in the suburbs as a very little child. And we would go back and visit sometimes. And I seem to remember that people would play ball in the street. They'd set up nets in the road and play hockey. And it was called street hockey.
Yeah.
And so the answer is, I think if you get your kids out on Interstate 81, well, there's nothing going on there now, but generally that would be a problem. If you live in the cul-de-sac area, it probably is a tragedy waiting to happen under some circumstances. But millions and millions of boys and girls have survived playing in the streets, sometimes because that's the only area in their neighborhoods to play in. So I'm not certain that that's per se child endangerment, although I can guarantee you that the safety Nazis that exist in full force these days will certainly find it to be offensive.
Well, Carl, even when people are on the phone texting while they're driving, right, which does not create a endangered environment?
Well, the most dangerous thing people do in the car is eat.
Well, okay.
And they've been doing that forever. But my point is, I understand your theory of how it could be child endangerment. But I think it's a case-by-case situation.
Well, the reason I'm saying this is because I was hit by a car, and I told my neighbors about it, and they think I'm stupid or something. And I told them, I said, you know what? It doesn't take very much for somebody to be driving, talking on their cell phone or texting while a kid decides to come in between cars and then play basketball in the street, which I believe is child endangerment. Not only that, especially if you have custody of your children and you're having them play in the street, which can end up in domestic court. But
well, it can. In fact, I've had opinions that I've seen where the courts have said Dad can't fly with his kid in the airplane between Pittsburgh and, central Pennsylvania because that's excessively dangerous.
Yeah. Okay. All right. Well, I guess that kind of answers my question. The other one is final restraining orders. I got a case where a gentleman has a final restraining order for 25 years. Now, here's the thing. What are the odds of getting a final restraining order dismissed if there's no violation?
If there's been no violation, if we're talking about a final restraining order, what state?
New Jersey, the People's Republic.
Oh, see, yeah, and I don't know the answer on that one because we don't have such a beast here. We have the PFA, which expires after 3 years or has to be renewed, but it can be terminated at any time by application of either party.
Well, New Jersey doesn't. It's for if you don't do nothing or make any moves, it pretty much stays there in place.
Right.
Unbelievable. So Pennsylvania's 3 years then, right?
Yeah. Although it can be extended, so you have to be careful. All right.
Yeah, but they have to be notified if it's going to be extended.
That's correct.
Right?
There should be a hearing on it. But wouldn't be the first time I've heard of somebody getting something done to them by court without knowing about it until after the fact. And then when you eventually untangle it, you've already spent some time in jail.
Really?
Or like a client I have right now who didn't realize the PFA was still in effect because he thought it was dropped because that was what he was told. But the person who told it to him was the person who got it against him, and she didn't understand that she hadn't fully dropped it. Her lawyer had just modified it. And they didn't have any problems except that he went to buy a firearm and got zapped for being subject to a PFA. And, of course, he's like, I was told it was dropped, and I figured that was good enough. And I understand why he believes that because he was told that. The wife says that. She says, I told him it was dropped. I thought it was dropped. I didn't understand that my lawyer just modified it.
Yeah, but you can't buy a firearm. If a final restraining order is already in the system, you can't buy a firearm.
Well, once it expires, you can. So
once it's been through the computer and they not either expired it, but it was dismissed and
right. And his problem was it hadn't happened yet. So of course, when he filled out the little yellow sheet, he said, "No, I'm not currently subject to a PFA." Mm-hmm. And my point on that just is sometimes the information people get, he wasn't aware of the actual proceeding or the paperwork that happened on the modification. And he just took his wife's word for it that it was dropped because that was her terminology.
Oh, that's interesting. That's really interesting. You always could trust your wife or your girlfriend, whatever.
Right.
So, okay. Thanks
or your boyfriend.
All right. Take care.
All right. Oh, boy. 540-0580. Jason, you're on the air.
Hey, Carl, how are you?
Good.
Hey, I got a question about LLCs. I started an LLC a couple of years ago for a rental property. I have a rental property. Okay. And I was wondering, if you want to start a different business it encompasses a completely different subject matter, can it go under the same LLC?
Unless the LLC has a operating agreement that restricts its scope of action, it can go under any LLC, even the one you already have. So,
I'm sorry, say that last part again.
It can go under that LLC. So in the old days, when you had a corporation, you had to declare what it was going to be for, and an LLC is sort of like a hybrid form of a corporation that's come around later. But you would go to the Queen and you would say, "Hey, I want to import tea from India," and voila, you're down the East India Tea Company, okay?
Right.
And then you would go to the Queen and say, "I want to make mustard," and she'd say, "Okay, you're now Coleman's. By appointment of Her Majesty, you may make mustard." So originally, corporations had a charter, and that charter controlled what they could do. And if they did something that wasn't inside their charter, it was called an ultra vires action, and they couldn't do it. And so you could shut, if as a shareholder or as a interested party, you could prevent the corporation from acting outside its charter. However, under the modern corporation laws and the LLC laws, etc., it basically says for any business purpose. So legally, you start out being able to do any lawful business, basically. And then you can circumscribe it by your own internal documents, bylaws, and orders, and, all those good things.
Yeah, there's no restrictions internally on it. I didn't think there were any restrictions on any business. I just wanted to make sure before I proceeded with
talk to your accountant, too, about whether or not your new line of business is best kept inside the LLC or not kept inside the LLC, or whether there might be some advantages to having more than one entity.
Yeah, that was my next step.
All right.
I have another question for you. I know you had the intellectual property lawyer on a couple of weeks ago.
Kelly Keller.
Yeah. I don't know if you'll know the answer to this, but in terms of intellectual property, if I have a logo I want to trademark, and I go to somebody because I want the logo, I have the logo, but I want to create it on a computer and don't have the means to do it on a computer, it's still my property because I'm hiring them to create it. Not
Correct.
To create it, but to put it in computerized format for me.
I think that's correct. I remember what she was talking about is when you have somebody mark it up, the copyright, I think, actually you can have dual ownership in it somehow. But you can have that person in the beginning when you hire them restrict what they can do with it. I'm thinking that's right. I'm trying to remember if the patent, which one was. One of them is sort of a weird dual ownership for the creator, but the beneficial interest belongs to. So
that involved that you were the employee of a company that chartered you to create it for them. Yeah.
Right.
This is I've created it and I just want it put on.
Right. So you're going to hire somebody to do it for you.
Yes.
I would still recommend getting in writing that they're going to be given information, including information about logo, trademarks, and other potentially copyrighted materials, and they agree not to share them, disseminate them, or profit from them later.
Yeah, just get them to sign off that it's still mine, yeah.
All right, brother. Got to go to break.
All right, thanks.
540-0580. Oh, yeah, it's some bad music there. You know what movie this is from, Art? Oh, come on. It's little Bon Jovi. Talking about the Republic of New Jersey earlier. Oh, you don't know. Oh, Young Guns. Billy the Kid, man. Good Lord. All right. Well, all these cowboy hats around here think they would know. Which reminds me, send in Walker, Texas Ranger, to check out the fertilizer plant, right? That's what they're going to do. Which also reminds me that Chuck Norris, they were going to put him on Mount Rushmore, but the granite wasn't hard enough for him. All right, anyhow, there's a whole series of Chuck Norris stories. Mike, you're on WHP 580. What's going on?
How's Carl today?
I'm pretty good. I'm going to go to Smoke Cigars and talk about guns at 4 o'clock at the Harrisburg Beer and Cigar over on Union Deposit. I'm hoping people will show up for it. A little trafficy out there, but you can still get there, and they got beer and cigars. So what more do you need?
Yeah, I agree. Hey, this truck driver that upset that, what do you think the ramifications? This guy has created havoc I haven't seen in Harrisburg area in years, not counting just realizing what it's going to cost the taxpayers to fix that bridge. State workers all let out 2 hours early. I had to go to Harrisburg. It was a nightmare, and it was something I had to be at 6 o'clock at graduation, and just trying to get in Harrisburg, it took me an hour and a half.
Yeah, when I was in high school, I dropped the ball in the championship softball game, and I still hear about it.
Oh, okay.
So
I don't think this guy's going to be driving truck for the rest of his life.
so these things have a way of sticking with you. That said, the answer
I know
is
he didn't kill anybody, but my God.
Yeah, and the answer is it was an accident. Now, some accidents have greater consequences than others, right?
Yeah, but you tip over a truck. It's usually you're going too fast. Isn't that the case?
That's usually the case. But I'm just saying, but it's an accident. And so it's human negligence. So if let he who's without sin cast the first stone, so to speak.
Well, that's true. But
And so human negligence is just, so here's the thing I hear people say. We had a driver on earlier, which I respect his position.
yeah, I agree with him.
But here's the answer. Why is it, for instance, I don't know if there's a lot of great studies out there on engineering, okay? And when it comes to dealing with human beings, you have to over-engineer everything because people simply won't do what they need to do. So, for instance, if you put a button on a Pepsi machine, you've got to over-engineer the button because people won't just push the button. They'll press on the button with their full body weight.
Well, that's true.
And my point being is just that we all go through life like a bunch of meatheads. We're good at what we do and what we're focused on, but we probably all make mistakes that we don't even realize we make because most of them never lead to a bad consequence.
Well, that's true. And nobody's perfect.
Right, and so I'm just saying,
wow.
I'm not for saddling any human being with all the incidental and consequential ripples that come from an accident like this. If he tipped over his truck, he's certainly responsible for maintaining a safe speed. There seems to be some scuttlebutt on my Facebook page. Mr. Fish believes that he was cut off by a four-wheeler. Of course, all truck drivers.
So where it happened.
All truck drivers believe that accidents are caused by four-wheelers. That's the last I checked.
Well, I will admit that there's been accidents in that area before on trucks tipping over. Never to the extent of diesel fuel.
Yeah, well, the problem is, of course, you got the slosh in there, and who knows exactly what happened and why. And he may have been. Apparently, he was an experienced driver. Now, is what I'm hearing.
Yeah, he's 55 years old. He was no young.
Yeah, and they're saying 30 years of driving experience.
Oh, did it say that there?
That's what I heard. Yeah.
Well, accidents do happen. I'm not saying that he.
Yeah, no, and what? You're still responsible. I rear-ended somebody not too long ago because the guy in front of them stopped short. He had to stop short, and I was the last guy in line who didn't quite stop short enough. And that's my, it's my that was my fault. I got to maintain a sure, clear distance, and I shouldn't have been plotting and planning my next court move or something in my head.
That's true. Well, I just realized I didn't realize. I mean, I knew that was busy up there, but how many thousands of cars are going through there? Especially at the end of the weekend. Like coming into the weekend.
Well,
Friday afternoon.
And what happens is it's that spillover effect too, because all your other roads are already at capacity, or people have kind of designed their routes around capacity, and this area is becoming what other areas have been for a long time, which is very trafficky. So I had an uncle who lived in California, and he lived there, worked for Hughes Aircraft, and he commuted from Woodland Hills to some facility. And his story was that when he first moved to California, it was a 45-minute commute. And when he left California, he still worked in the same building, and he still lived in the same house, but it was a 2-hour and 10-minute commute.
Oh, I believe that. Especially up your way. I don't get up that way often, but boy, the traffic is a heck of a lot more down in the Lebanon area.
I go up and down 81 quite a bit for court, okay? And I go up to Sunbury sometimes, and I go out the Turnpike. I like the Turnpike the best because it's the easiest and fastest way to get anywhere if the exit's in the right spot, okay? So the Lebanon County Courthouse, the Berks County Courthouse are very easy to get to. Over the years, though, going 81 south from Carlisle, and I've been driving down to the Chambersburg Courthouse there for 15 years. I can tell you for a fact that 81 has 3 times as much traffic on it now as it did 15 years ago, going up and down between here and Chambersburg.
Oh, I believe that. Wait, wasn't it in the paper like 2 weeks ago? Cumberland County had the worst air. Of course, they were blaming it on all the trucks. Worst air.
Yeah, they say from the diesel idling.
Pennsylvania. Well, that's always nice to hear if you live in Cumberland County.
And part of the problem is because of the valley and the way everything's set up. I don't think the wind purges through there that much.
Well, they did say that. They didn't blame it just on the trucks, but they did bring out about all the trucks.
Well, and I think I've heard that at some point in an evening, if everybody's in there tucked away in their sleeper cars and everything, we can have as many as 5,000 trucks in Carlisle in an evening.
I know there's a lot up there when I get up that way. Then.
So.
Okay. Well, you have a good day.
All right, boss. Thanks. 540-0580. Mike, you're on the air. What's going on?
Yes, hi. Also calling about a trucking issue.
Yeah.
A lot of the truck accidents when there's fatals. Now, there was only one this time so far. You never really hear the victims come out afterwards about the accidents and speaking out and saying what happened. Are they getting gag orders, per se, in the court settlements, or any idea what's going on?
Yeah, well, there's definitely in the court settlements almost always includes a confidentiality clause. Don't talk about it, can't talk about it. The other two things that I think happen, quite frankly, is a lot of times on the interstate, sometimes the people are local, sometimes they aren't. And when they're not local, I don't think the newspaper and the human interest section whips up as much interest in it either. But I do think a lot of times it's because there's a tragedy. The family's not really going to come out and say much. They're coping with it. And then in the meantime, by the time they get a plaintiff's attorney, everybody says, don't. Because here's the problem. If my client, and I've done some, and I do a lot of personal injury work, and if I have a client who's been hurt and they want to go to the newspaper and describe how, such and such store destroyed their life by letting something fall on their head, right? The problem with that is once you let the cat out of the bag, there's no incentive to the other side not to let it become a public matter either. So you only hurt your own negotiation position by being too vocal too early.
I guess I'm looking at more, let's say, from like a MAD perspective, how they form Mothers Against Drunk Driving. You need somebody, if they want to take action against some of these trucks who aren't obeying the laws, they need to come out and speak out. That's what you almost need. Somebody to get out there and get public about it and say, this is what's been going on. They're trying to keep me quiet.
Right. You need a little girl to get run over so the legislature can name the legislation after the little kid. I mean, that's kind of right how it works these days. Yeah, everything has a, it's Megan's law, it's Susie's law, it's everything has a name because it's supposed to be part of a cause. And you're right. You have to have a cause to move things forward.
Do you know offhand if something like that were to happen and it was one of your clients, would you ever encourage them not to take the gag order?
It all depends on what's in their best interest.
Yeah, if they were saying, look, I don't care about the money, I want this dealt with.
I had a client one time. I'm going to let you go, but listen after the break and I'll tell you about it.
Okay.
540-0580. Welcome back. Carl Ramage here, 540-0580. Oh, boy. We're going to get my mom on the air in the next hour, I hope. Tried to get her on the Durgan show yesterday, but I don't know what the heck happened to her. I haven't talked to her yet today, so maybe we'll get a hold of her. Maybe not. Maybe I'll have to send the neighbors over to knock on the door and, see if she's in there. Amy.
Yes, hi. Hello.
How are you?
Good, how are you?
Not too bad. What's going on?
Well, I had a couple of legal questions about the gun laws in Pennsylvania.
Now, if you smoke cigars at 4 o'clock, we can answer those over at Harrisburg Beer and Cigar, which we're doing today. But if you want me to answer them now, I will.
Okay, could you answer them now? Because I'm not a cigar person.
Okay.
Sorry.
we can smoke pipes, too, and hookahs.
Well, no, not really.
The peace pipe, too. There was a guy in Durgan yesterday called up and wanted to know about the peace pipe he bought as an Indian artifact and how if he was driving around with it, the police think he was a marijuana user.
Oh, no.
And I was like, they do call it smoking the peace pipe. So,
well, that's true.
All right, go ahead. I'm sorry. I
Okay,
distracted me.
Here's my question. I have a friend who, back in the 90s,
Everybody has a friend. Nobody actually wants to say about them. But go ahead, tell me.
Well, he doesn't want me to use his name.
No,
so.
I understand.
But anyway, back in the 90s, he was arrested under the Drug and Cosmetic Act for growing marijuana plants. But he was never convicted. They dismissed the charges because of invasion of privacy on his property.
Yeah.
Okay, and recently he went to go get a concealed weapons permit, and they denied him for that. But he's concerned that he may also be denied to buy any firearms.
Now, a concealed carry permit, if you violate the Drug and Device Cosmetic Act, even a minor portion of it,
Right.
then you can be banned from having a concealed carry permit, okay?
Okay.
Although I don't think that's right, by the way, but we'll talk about that later. On the other hand, if he was completely acquitted, then he has the right to get an expungement. And then the next time he applies for a concealed carry permit or goes to buy a gun, nobody would even see that record.
Okay.
So
he could get his record expunged, and then he actually could get the concealed weapons permit as well.
Yep, if the case was dismissed. And actually, technically, they probably should have given it to him if the case was dismissed. The sheriff really can't hold it against him.
Right.
But expunging it will prevent that problem because then there won't be anything for them to point at to hold against him.
Okay. But does he have? Should he have any worries about possessing a firearm now? Like as far as just owning guns to go hunting?
As long as he wasn't convicted of a misdemeanor carrying more than the potentiality of 2 years in jail or a felony, then he should be fine.
No, he wasn't convicted in any of those things.
Yeah.
So, he's just nervous, and we didn't know how to go about finding the right answer. And we've seen many, many things, and everybody seems to know the answer, but he doesn't want to have a problem, if the police come knocking on his door and they come in the house and there's guns in the house.
Was he arrested in Pennsylvania?
Yes.
He should just go get his certified criminal record from the state police. Just go to the state police website, pay a few bucks, and get the certified history, and that way he'll know exactly what he has.
Okay. I have looked it up for him previously on the judicial court website in Pennsylvania because I have access to that. Through my job, and I've looked it up so we know what it is, but we weren't sure about the legality of can he own a firearm?
What was the final disposition of the case?
I don't have it with me right now.
Dismissed, guilty, or not guilty?
It was one of those Latin terms like
nolo prosequi?
Something like that, yeah.
But hopefully not nolo contendere, because that will act as a conviction.
No, it's not a conviction.
If it's all nolo prosequi, it means it was non-pros or no prosecution.
Right, because the state police ended up, the judge found...
The evidence were thrown out, so what happens, the evidence was suppressed, and the government, without evidence to go forward, chose not to proceed with the prosecution, so they null-pros it, and he is entitled to an expungement. I would strongly recommend he follow up with that.
So should we just hire an attorney and file the paperwork for that, or can we do that ourselves?
You could do it yourself, but I always like to say you can change your own oil too, but sometimes you need a wrench and blocks and oil.
Yeah, it's probably better to have a legal person do that for us.
Right. All right.
Okay.
Thank you, Amy.
Well, great. Thank you very much, Carl. Have a good afternoon.
You too. 540-0580. James. What's going on, James?
James?
Yes.
Thank you for taking my call. We live in what's left of the country here.
Okay.
And we have about 30 acres surrounded by a couple hundred acres of woods. We have a range here that we shoot a little bit.
Okay.
I shoot very seldom, but my grandkids come and shoot and so forth. Well, last Sunday, there was no shooting, no one here at all day. I went out to a sale that I go to on Sunday evening, just to look at the preview. It's an antique sale to see what's there. When I come home, I pulled in my driveway, and I saw two police cars at the neighbors, two state police. And I stopped and talked to an old Amish couple that I knew that were walking home from church there. I was only there a second or two when the state police cars run up behind me. Police cars at this neighbor's is nothing new. This happens on a quite regular basis, every week or a couple weeks. So one of them come up and he wanted to know my name, and I said, well, what does this have to do with me? And he didn't like that answer.
Right.
Well, then, apparently, the neighbor said that there was a bullet hit their house. It bounced down over the porch roof and out into the yard. And they had found this bullet. And my name was brought up. Well, he had the state police had the bullet. It appeared to be a 380 9mm, something like that, full metal jacket bullet. I don't know how we got around to I was carrying a .45, which of course he wanted to see that, and I do have a carry permit. I give him the .45 and the carry permit. Of course, they had to run back to the other police car and run it through all the whatever.
Right.
Well, then.
Oh, you've got to hang over the hour for us here. Everybody's dying to hear the rest of this. Hold on.
Okay.
I don't know if they're dying, but I'll be back in a little bit. 540-0580 when we get back from the break. We'll hear about the story because I am kind of interested where this is headed. Do you have a legal question you want answered? Go to RomingerLaw.com. That's RomingerLaw.com. RomingerLaw.com to get your question answered.
Advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, welcome back. James.
Yes.
So let me summarize for the people who are just joining us here on WHP 580. This is Carl Rominger. We answered legal questions. You had an incident with the state police. You have a shooting range or an area in your land where you do some safe shooting, and you were confronted by police over a bullet that somebody in a neighboring house claims to have found having bounced off of a roof.
Mm-hmm.
And what happens with the state police then?
They looked at the .45 I was carrying, grudgingly gave it back to me, said something about taking all my firearms and testing them to see if this bullet came from any of them. Now, this was last Sunday, and this hasn't happened, so I'm hoping this is over with. But is it possible that it's not over with yet?
Yeah, it's possible. They would need to get a warrant if you don't want to hand this stuff over.
Yeah, all right. Now, here's my question. I've lived in this house for 40 years, my wife and I. You can imagine the nightmare that would be to have police rummaging around in your house searching for this and that.
Correct.
Okay, I have other guns. I have some old guns that my father had given me. I have some stuff brought back from Germany from the Second World War that my uncle and so forth and so on. Now, this bullet that was supposedly found appeared to be a .380 or a 9mm. Now, could I keep them from gathering up shotguns and .22s and .30 caliber rifles and things like that and dragging this stuff all out and off someplace?
No, because what the police are going to do is they're going to write an affidavit that says we found a bullet. Bullets come from, in my experience as a police officer after many years, bullets come from guns, Judge. And as a result, we believe that by checking the bullet against the guns owned by the defendant, we may be able to match the two up. And then the magistrate will sign it probably. And unless you got a good magistrate who's really paying attention, and some do, but a lot just sort of leave it up to the police. And so once they seized all your guns, the only thing you could do is go to the court and say, hey, I want all my stuff back. There's no reason for them to seize these items because they're looking for a rifled bullet and of a particular caliber or range of calibers. And what do they need any of my other guns for? But, yeah, I mean, you have that problem.
I think there was a comment made that I'll never see them again.
Well, there's also the comment that the police make a lot of times, like, you're going to go to jail forever, and we're going to put your kids in children's services, so you need to confess.
Yeah.
Or my other favorite one is, we've impounded your car, and if you want to get it out of impound, you're going to have to confess. You know, I like that one. Then we always stick them with the tow bill later when the client comes to see me.
So there's no way of to prevent them from dragging off everything I own?
There's nothing to prevent them from executing a lawful warrant. However, there's nothing to prevent you from suing them later for violating your civil rights, for making the warrant overly broad and excessive when they should have known that they didn't need those things.
Well, if would the warrant say they were looking for a bullet that come from a 9mm or a...
No, that's the problem. A warrant just is whatever a judge is willing to sign.
Okay.
And your problem is once the judicial signature is on there, you can't disobey it. They can, lock you down. The detached neutral magistrate. Remember that, folks, when you're voting for district judge. Remember, that's the guy who signs the warrants.
This wasn't the news I wanted to hear.
Yeah, I can't tell you. I mean, I can't give you any better answer than that. All right, my friend?
All right, thank you.
If you
very
need
much.
anything, get a hold of me off the air, and we'll take care of it, okay?
Okay.
All right.
Thank you.
Carl wants me to, the other Carl, atheist Carl, wants me to, I'd like to call him that just for fun. He wants me to finish the story. He's like, would you finish the story you promised us? I had a woman one time, they ran her name, date of birth, and social security number in an advertisement. It was a doctor holding a folder with all this personal data on it. And it ran in some newspapers. And, she was adamant that she wanted to take it to trial and didn't really care if she won a lot of money or a little money. She just wanted to win so that she wasn't bound by a confidentiality agreement, and that she could go forward and tell the world about how she was wronged by this particular hospital. And to this day, she's free because we won a verdict, a nominal verdict, but a verdict nonetheless, because there wasn't a lot of provable damages. But the jury gave $2,500, which really wasn't a ton of money. We almost got punitives, though. We were really close on the punitives. And cha-ching, cha-ching. But we didn't have enough. We only had 9 jurors. We needed 10 jurors to get the punitives. And the hospital in question is a charitable hospital, so their big defense was, well, don't punish us, even though we did lots of bad things, because we're a charity and you only take away from serving the public. So punishing us is like punishing yourself. It persuaded 3 jurors. That's all the other lawyer needed. He was a very good trial attorney, by the way. So I was hard-pressed there. But nonetheless, she got what she wanted. What she wanted to do was to be able to run around the world and tell everybody about it. And she does that to this day because she did not have to sign any settlements or anything that required her not to speak ill of the other party. Of course, they could speak ill of her, too, but that would probably be hard for them. 540-0580. Let me see here. Shane, I'm going to see if I can get my mom on the phone here.
Is this going to turn into a daily ritual every Saturday?
Not every Saturday, but we got to check on her. This is a good time. This way I can get my son duties done at the same time so I can go smoke cigars. Hello? Hello? That's still ringing. I'm like the old person. Hi, hello?
Did you get her for Mother's Day before she gets on?
Shh. Nothing.
Hello?
Mother, how are you?
Oh, I'm fine. How are you?
Good. What are you up to today? It's Mother's Day tomorrow, so happy Mother's Day.
Well, thank you very much. Oh, I was out doing my job as assessor this morning, and I just got home.
Yeah,
So
okay.
I was busy, and I was going to plant things today because a friend of mine gave me shallots, but it's too cold.
What's the weather like up there in Western New York?
It's wet, damp. We had a call for a tornado.
Yeah.
People got alerts over their phones and stuff, but not last night. And then today it's just turned cold. It was totally foggy. I could barely see where I was going up in Arkwright.
Well, we're having traffic Mageddon down here. Interstate 81 is out right now in a major pass, and there was accidents everywhere else. So the entire midstate is a jam of cars right now, literally.
No kidding.
Yeah.
Wow.
You'll have to look it up on the internet.
I will.
You've got that computer worked out, right? You can use that now?
Yeah.
Okay, good.
And I sent you another recipe.
Oh, good. What'd you send us? Can you give me a hint?
Yeah, bishop's bread.
Ah, what's that?
Okay, this is the bread that is a fruit cake, but it's a fruit cake that everybody likes. It's made with chocolate chips, walnuts, dates, dried cranberries, candied cherries, and maraschino cherries.
Okay. By the way, I
Right?
did get some feedback on your guacamole. A lot of people were making it, and everybody seemed to like it. So,
Good. I'm glad. I mean, that's one of my most favorite recipes.
so what I want to ask you was, because a lot of the callers want to know what you think about this Benghazi thing with Barack Obama.
Oh,
You have any thoughts
dear.
on that?
Just the thought that the truth should come out as to what it is and what really happened there, because our people, whether they be State Department people or soldiers, need to have the most respect and be protected as best as we can do it.
Seems fair.
Yep.
Well,
and that's kind of the whole thing, is that everybody should be treated and kept as safe as they can be, and it doesn't seem to have happened in this instance.
Yeah, I think there's more shoes are going to drop there. It sounds like I'm pretty confident that whole thing was smeared up because right before the election, no one wanted to admit that we were still being assaulted by radical Islamists on 9/11. So just like we pretend the Syrians didn't use any chemical weapons recently, I think that's kind of what the issue is.
Well, that could very well be. So, what else is going on in Pennsylvania other than having one huge traffic jam? And unfortunately, some people have damaged cars and damaged bodies.
Yeah, and we did have a fatal as well. So it was accidents all over the place, things on fire. I was filled in for Bob Durgan yesterday, and I opined that I thought I was going to die of a biological weapon or a nuclear attack or just good old-fashioned old age. But instead, it's going to turn out that I'm going to die sitting in my car in the mid-state, just of old age. Trying to go from A to B.
That could be. I have never seen so much traffic on the thruway. I've had to go to Buffalo a couple times this week, and I can't believe the traffic. It's one truck after another, and the cars are lined up like I've never seen them lined up.
I don't know, and maybe spring has sprung and everybody's going somewhere. I don't know.
I guess.
Well,
I don't know either. Well, listen, are you?
Yeah, you're on the air. Did you know you're on the air, right?
I know I'm on.
All right.
Yes.
All right, Mother.
All right.
All right. Love you. Happy Mother's Day.
Yeah.
We got to go to break. We have to break even with you.
Okay. Bye.
Bye. Oh boy. But she sounded okay, right? I mean, she didn't sound ill or anything, right? Yeah, good. Yeah, I worry about her. She's about 810 years old. Oh boy. I wonder if she even knows I'm really one of her kids or not. All right, Brian, you're on the air.
Yes. At a district justice hearing, who can appear on behalf of a corporation?
Yes, interesting question. Theoretically, a corporation must be represented by a counsel, okay? However, district judge court, there's a rule that allows the corporation to designate a person, or an LLC to designate a person. And if you go to the rules of district judge procedure, there's a rule and a form for it.
Okay, I mean, if it's a major corporation and they send somebody way down the food chain to represent the company.
Yeah, they have to fill out the designation, theoretically.
Okay,
but a major corporation is going to just send a lawyer, and the lawyer can appear on behalf of the corporation. He can't testify for the corporation, but he can appear for the corporation.
Okay, but if you were in that position and they sent some low-level employee there, you could...
If they send anybody but a lawyer, okay,
right,
then they got to have that form, and they got to have it filled out in advance and designate that person.
Okay, a decision that was made, and they had sent somebody like that. The decision was made. Does that nullify the decision?
No. What a district judge does in any civil action is appealable within 30 days of the court of common pleas, what we call de novo, meaning it starts from scratch. So your remedy of any kind of error like that is to file your appeal.
All right. And in general, in litigation, is a corporation required to use outside counsel, or can they use inside?
They can use either or, but the person for appearing in court has to be admitted to the bar of the state they're appearing in.
All right. And if I may, in terms of a civil case, you had mentioned punitive damages earlier.
Yes.
If you, let's say you're involved in a case and the other side's dragging things out, there's discovery that's gone on for years and years, that in and of itself is escalating. But let's say this thing finally hits trial. Can you then, if you're not represented, if you're pro se, can you make a claim that while you were burning up time running back and forth to the courthouse, that it was preventing you from doing your second job and putting together a case that you were...
You should be moving for sanctions internal to the matter, not at trial. You could, so your damages there, I don't think really any litigation expense, time, etc., is not cognizable in the case, but it is cognizable at sanctions if you have to do excessive work, etc. and actually good sanction work. You can preclude particular evidence, discovery materials, etc., if they weren't timely provided or there was problems with them, etc. So, but yeah, I don't think you can go to the jury and say, oh yeah, by the way, these guys have been really crappy during the litigation, and here's how they've drug everything out. There is, however, something called delayed damages, so you do get interest back to the time of the event rather than the time of the verdict. So you have the ability to get some additional money. Unfortunately, delayed damages are tied to the actual honest-to-God interest rate, which is like, -3 right now.
Correct.
All right, my friend.
All right, thank you.
Thank you. 540-0580. Mike, you're on the air.
Yes, I just have a question about my visitation rights with my daughter.
Okay.
I live in Carlisle. My daughter lives in Castanea outside of Lock Haven. I would like to start having her come down with me for when I visit her instead of going all the way up to Lock Haven all the time to see her. But my daughter's mother told me that that's not going to happen until we get it in a court order that specifically states what time I'm to pick her up and bring her back and where I can and can't have her.
Well, what's so bad about you?
I don't know. I haven't done anything to warrant her to do or say anything like that. I think she's just being hard-nosed about everything.
Right. Well, you can go back for conciliation. You file for a conciliation hearing, and hopefully you can hammer it out in an order you both live with. And if you can't, then the court can eventually order her to an order you can live with. But it seems. Oh, go ahead.
I just like to have her down with me so she can see my parents, and because she's hardly ever seen them.
Right. And the answer is, a lot of times people want to micromanage what the other side does when they have the kid. Mm-hmm. Absent some history of abuse or neglect, or you're living with a Megan's Law offender as a roommate, or your dad's an alcoholic, child molester, one of those sorts of things, then the courts aren't going to micromanage what you do during your visitation times.
Yeah, because there's nothing like that. There's no reason for her to be that hard-nosed about other than the fact that she's a bit of a control freak.
Right. Well, and sometimes in custody matters, and I don't know what the history of the case is, but sometimes we've run into but I've never been away from my kid that long before, which they never actually say, but it becomes a driving force in the custody case. Yeah. And so there's a million reasons why, well, you can have the kid when the moon crosses in Aquarius and you put in paper the hours and the times and the days of the end of the world, because I'm really making all that up because I just don't want to be away from my kid for more than 3 hours.
Yeah.
That sometimes is the issue, too, which I understand. You have a child, so once you have a child, you understand that. But the flip side is, if you have a split-parent situation, you have to share.
Yeah.
All right, Mike. If you need some help, let me know.
All right, thank you.
All right, boss. 540-0580. Don, you're on the air. Hey, Don.
Hey, Carl. Thanks for taking my call.
No problem.
Real quick, straightforward custody question. At what age does the court take into consideration the child's wishes as far as where he or she lives?
Well, I mean, what the child's preference is on where to live?
Yes.
Pennsylvania law says that it is one of the factors to be considered amongst the 15 enumerated and one catch-all factor. The well-reasoned, opinion of the child and desire of the child is to be considered and formulated in the best interest analysis. And we don't have a magic age in Pennsylvania. So the older the child is, the more weight a judge often puts on what they say, and the younger they are, the less weight. On the other hand, you can have a very young child who's very articulate or seems to actually have a pretty good grasp of why they want to be where they want to be or how often they want to be. And then you can have an older kid who's very immature and who's very clear to the court or the psychologist, just wants to be at dad's house because dad lets him, snog with his girlfriend.
Now, I'm talking about a 12-year-old.
Yeah, 12-year-old, 12-year-old's going to be listened to. 12-year-old doesn't control. I mean, if 12-year-olds knew what was in their best interest, they wouldn't have parents, right?
Mm-hmm.
So the theory is a 12-year-old's opinion is important. Just as you might go to your 12-year-old and say, listen, buddy, do you want to play soccer this year or swim? You got to pick. You leave that decision to the kid. But you wouldn't leave the decision about, whether to go to school or not to the kid. He just has to go. That's just the way it is. You're the parent, right?
Right.
So same thing with a 12-year-old. You're going to give them some input, but a court's going to have to weigh it against all the other factors in the case. So have you ever known somebody who was in a bad relationship, so they're in love with a woman who's just a total mess and destroying them, but they keep staying with them, or a guy who's just abusive and the woman won't leave, and you're like, why do they do that?
In my two professions that I've been blessed to be involved in my life, yes. I've seen that quite often.
So here's my point on that. So if we know that adults can want to be with the person who's not necessarily the best one for them, we can also imagine that kids quite often may pick one parent over the other for some reason or another, but they may not be the best parent. So the courts try to intervene in that and try to figure it out. Now, here's the problem. I mean, there aren't right answers, right? There are better answers, and there are sometimes obviously better answers, but how you know which parent's really better and what's really in the best interest of the kid is a crapshoot, with guys with robes basically making decisions based on some things crafted by the law and some experience, a lot of times, which turns out to be, I know another lawyer, and she was complaining recently about a judge who pulled a kid out of school in the middle of the year. And she said, I can't argue with maybe changing the custody around, that, it was a close case one way or the other, but why would you yank the kid out of school in the middle of the year when you're a month from the semester ending, and the kid can change it during summer break? Because so most judges will do that. So there's just different tolerances and experiences. So anyhow, wrapping this all back, what I'm trying to say is your 12-year-old, what they have to say is going to be important. To some judges, it'll be more important than others, and some reasons to the 12-year-old will be more important to some other judges than others. And if there's psychologists or custody evaluators involved, then you're going to get even different reads on what the 12-year-old really wants or is saying.
Okay, really basic background is that for 10 years, custody was an equal 50-50 everything. The child lived 1 week with me, 1 week with his mother, 1 week with me, 1 week with his mother. We maintained residence within a mile of each other.
All right, Don, I'm going to make you hold while I go to break, and then we're going to talk about it when we come back.
Okay,
hold on.
Great.
All right, welcome back. Carl Rominger here, 540-0580, answering all your legal questions. I want to remind you, at 4 o'clock, I'm heading over to Harrisburg Beer and Cigar, where we will be smoking cigars and talking about guns and the law. And that's open to the public. It's not a bring-your-own cigar, it's a buy-your-own cigar event. Maybe you can buy me a cigar if you feel like it. I'll probably smoke it. And that's at 3842 Union Deposit Road in Harrisburg. And traffic's not that bad, so get your butt over there. A very informal, fun event. I'm wearing a T-shirt and shorts, so it's nothing fancy. We're just going to talk about the Second Amendment, self-defense, and smoke cigars. You heard the ad for CDL Labor Logistics. They're looking for qualified commercial drivers with clean records. Call 866-293-1880. Those are high-paying positions for clean driver's records, PA, Maryland, New York, New Jersey, and local. 866-293-1880. I know the guy that owns that, and they're really good guys. It's a father and son team that run it. Very professional, very good at what they do, so I highly recommend them to you. 866-293-1880. Also, I'll be at the Lancaster County Women's Expo next weekend, checking things out, and maybe I shouldn't say that. Don, we want to talk about custody still. So the summation was you had a kind of a split custody situation, same school district and all those good things.
Yeah.
What was going on? Then keep going.
Well, we had a custody agreement that was completely 50-50 with, it even stated in our custody agreement that we would not take each other for child support. This worked out great for 10 years. The mother and I remained very good friends until she went to Australia and came back married. When she came back, she had a completely different attitude towards our friendship, and after a very innocuous text message, she filed a PFA order.
Okay.
I was told by my attorney, take whatever deal they offer, because this judge doesn't play with PFAs. The judge would not hear anything on custody in the PFA hearing, and all they were offering was supervised visitation, supervised by either one of my sisters or brother-in-laws, which live 2 hours away. And as you can imagine, that has not worked out very well, as they all work weekends, and I've only been able to see my son in the past year 5 times, when he's accustomed to living with me half of the time.
Right.
Every time that I have had visitation, he has said, when can I come back to live with you? And I've asked him, be honest, tell me what you want. Do you want to live with mom? Do you want to live with dad? Do you want things the way they were? And he very much wants to go back to the 50-50. I've been very involved in school activities and PTA activities. The problem is, for me, that she comes from a family with some money,
right,
and is able to afford, a decent attorney. And I'm looking at, going at this pro se.
What county?
Lancaster.
Uh-huh.
So I was wondering, how likely are they to? I don't even know if it's the status quo anymore.
Yeah, well, the status quo with emphasis on the last 6 months and all that good stuff still plays a big role. But here's what I would recommend. I would recommend going to court, and if you can't get what you want right away, get a order allowing for the child to see a counselor, and get the counselor's view on where the kid is at. Because one thing that happens sometimes with kids is you go all through all these steps, and then you get into the courtroom, and I go back with the other lawyer, and the kid's in there with the judge, and they just freeze,
Okay.
And so instead of saying, I want to be with dad or mom, the kid goes, I just want everything to be the way it is. Or, just something very nebulous that doesn't articulate well. Whereas if they've been with a counselor, the counselor writes up a report and says, he really would rather spend some more time with his father, but he's not sure how to break it to his mother because he feels that it would hurt her feelings, and he doesn't want her feelings to be hurt because he still wants to spend a significant period of time with her, da-da-da-da-da. And that way the judge gets it. And we had Arnie Scheinvold here on the show maybe a year ago, and that's available on podcast somewhere. He talks about that, how, they do, a counselor does hours and hours and hours of evaluation. A judge does 20 minutes. So judges will tend to put a lot of weight on what the counselor says because of their frequency of contact and depth of contact with the child.
And that would be at my expense, correct?
Yes.
Okay.
But here's the answer. Sometimes we do construction litigation. A guy comes in and says, I want to sue somebody. And I say, instead of spending $5,000 on attorney fees, let's go spend $1,000 on an engineer and get a report. And then my case is either going to be really easy and really sound, or you're going to know not to spend any money on an attorney.
Right.
And the counselor is a better way than full-fledged litigation. And if she's not agreeable to a counselor, if you go to court and all you say is, I want my kid with a counselor, almost every judge in the world says yes. All right?
Okay.
All right, boss. And I do have a Lancaster office in case you want to sit down and talk with me sometime.
Yeah, where is that located?
It's 1000 North Prince Street, but you got to call in because I'm only there by appointment.
Okay, and consultations are...
well, this is kind of your free consultation, but I'll give you a couple more minutes.
Okay,
all right, boss.
Gotcha. All right. Hey, thank you.
All right. 540-0580. Kevin, you're on the horn. Hey, Kev.
Oh, you say Kevin?
I did.
Yeah, involuntary commitment.
Yes.
We're at a local hospital. My daughter's 21. Obviously, we have been through this before, only we were on the flip side of it. We tried to get her committed 6 years ago when she was under our custody, which at that age they considered her not under our custody. Anyway, now it's the other way. Because of them two high-profile cases here, they automatically want to commit her for 5 days.
Mm-hmm.
And we don't think, compared to where we were to where we are today, we have made major progress with just her growing up.
Right.
But she's supposed to start her first job just tomorrow, and she did something stupid last night, but we go through this every 3 months now instead of every day. Is there anything we can do? Is there anything she can do? Because she's 21. They just tell us to shut up.
So they're trying. She's entitled to fight any institutionalization through the Mental Health and Procedures Act.
But can she do it from the hospital immediately?
Immediately, I think she's entitled to. There's protocols. So when they first bring her in, they've got to get her a hearing within a certain time period, and I think it's 3 days or thereabouts. And then the protocols from there again are updates thereafter, and I don't know how long or how far apart they're allowed to be. We don't as practicing lawyers too often get involved in those. I was out for one time, and I think we did one years ago as well. But the long and short of it is, usually you want a specialized practitioner, and they do appoint counsel to represent the alleged incompetent. So she should have a voice. But as for doing something right away, I don't think there's anything that can be done right away.
Nothing. They can just see. It's very frustrating because 6 years ago they said just the opposite.
Yeah, they wouldn't take her.
She can walk out.
Right, but here they involuntarily commit her.
You do, she's going to go.
They 302 her, and now they don't want to let her out. But she has the right to a pretty prompt hearing. So, but I just don't know the particulars of the case.
Yeah, the only paper they gave me is their treatment no longer than 120 hours, 5 days. She will get a more detailed version of the Department of Welfare regulations in 72 hours.
Right.
So this really means nothing to me. But
right, and that's the first. It's like a 3-day thing, and then it goes up to I think 120 days, but it could be more or less than that, and it has to be the minimum amount. And the psychiatrist or psychologist, I think psychiatrist, will then testify as to what they think is appropriate and what they're looking for to get the person stabilized. And generally, they're really not trying to keep people in these places because the funding's so poor.
Yeah, well, that's the other gripe I have, but that's a different argument. So there's nothing she can do. There's nothing.
Except to go through the Mental Health and Procedures Act. And I think she's entitled to that prompt hearing, but I think that's about it. And maybe an extra...
They'll incarcerate her before that hearing, correct?
Right. They'll pick her up and they'll put her in, and then she's entitled to the hearing. Because we allow for a temporary commitment first on a doctor's signature, but for no more than, I think, 72 hours. And then there has to be a ruling if it's not going to be voluntary.
Okay.
All right?
I guess.
I think that's the right answer, but don't take it to the bank.
Yeah, it's just hard to find other advice on a Saturday. I don't normally call lawyers on the radio.
Well, who does?
You were accessible.
All right. Thank you, sir.
All right, thanks.
All right. 540-0580. See you after the break.